is applying for to execute the wakalat. Or is not saying the wakalat. Why that name has been chosen?
No, I have so that's why I appreciate that you write a note. That I think she was really our Brazilian taking
ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರಿಬೇಕಲ್ಲ. Yes, you comply that off subjection. Pass out. ಅದೇ ನೋಟಿಸ್ ಕೊಡ್ತೀವಿ ಇದರಲ್ಲಿ ಅವರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಕಂಪ್ಲೈ ಮಾಡಿ ದೆನ್ ವಿಲ್ next week. Yes, now I am only pass it over. You first comply that, then I will fix the date. Yes.
Number 13, Shantaraj K for appellant, B.S. Umesh.
Yes. Where is Umesh? Pass over. Yes.
Number 14, Shantaraj K for appellant.
ಯಾರು ಓನರ್ ಅಪೀಲ್ ಇದೆಯಾ ಅವ್ರದ್ದು? Wait, we'll see. That matter is called. Password.
Number 15, Shantaraj K for appellant, Manjunath Reddy V.J.
Furnishing up. Postal acknowledgement track report consignment details not found. Then you have to take first steps. Who is R1?
The owner really claim petition has been dismissed. Otherwise, sufficient.
ಎಲ್ಲ ಬಂದಿಲ್ಲ ಅದು. Nothing has been come. Track reports is consignment. Detail is not found. Whether it is served or not, you take one more steps. Let us see. Yes. Week's time is granted to pay the process. Issue notice to R1.
Number 16, Satish Reddy for appellant.
Second respondent, Liberty Video General Insurance.
Learned counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Notice to R1 is dispensed. Ravi Sampratis is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies. Huh? Why? You want to read? Office is directed to return the TCR to the tribunal forthwith.
Number 17, Raghuwar for appellant, Reliance General Insurance.
You have filed wakalat? Yes. Learned counsel for the appellant. Ready now?
Understand, my lord. Fracture of both ones of left leg, my lord.
That's
Doctor status 33% disability and whole body 11%. My lord, court has taken 8%.
Earlier discussion.
Question, my lord. Para number 14 of the judgment.
Yes.
Pain and deformity of left leg shows that LL bones, distal 1/3 bones of both bones of fracture of left leg and other injuries all over the body in the said accident, and the injuries have resulted in disability, thereby affecting loss of future earning capacity.
11% disability to whole body. Doctor ಎಷ್ಟು ಹೇಳಿದಾರೆ?
33% to 11%.
ಎಲ್ಲಿ 33% ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
33% is single element. 33% ಅಂತ ಇಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ, 11% whole body ಅಂತ.
ಅಲ್ಲ 33% ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಾರ ಡಾಕ್ಟರ್?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಲಿಂಬ್ಗೆ 33.
11%
whole body.
To that suffering 11%. Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
8%.
What is that income?
Income million 1/8/2019 million. Date of accident. Court has taken 9,000 million. We are claiming 20,000 per month.
Yes. How many days you were in the hospital?
5 days.
Pain and suffering 9,000. Medical expenses, food and nourishment, train charges, loss of income during the later period, loss of future earnings, loss of immunities. Interest?
6%.
Yes, that's all.
Future medical, I was for help.
ಇಲ್ಲ ಹೇಳಿದ್ದಾರೆ future medical.
Para number.
Yes, that therefore doctor evidence ಇದೆಯಾ?
Yes.
ಎಲ್ಲಿದೆ? ಮತ್ತೆ why they have
ಅಲ್ಲ ಇಲ್ಲಿ para number page 17 of the judgment.
ಆಯ್ತು ರೀ 15,000 ಹೇಳಿದ್ದಾರೆ ಯಾಕೆ ಅಂತ ಏನು ಹೇಳಿಲ್ಲಲ್ಲ ಇಲ್ಲಿ.
Future medical.
Yes, tell. So and so learned counsel appearing for climate has contended that due to that accident, climate has suffered grievous injury. Doctor has been examined as PW2. With evidence, he has deposed that climate has suffered 33% disability to particular limb and 11% to whole body. Tribunal has assessed whole body disability 8% is on lower side. Secondly, he has contended that at the time of the accident, climate was earning 20,000 per month. Tribunal has assessed notional income of the climate as 9,000 per month is on lower side. Thirdly, he has contended that due to that accident, climate has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Order sheet ಅಲ್ಲಿ learned counsel for the appellant has filed a memo seeking dispensation of notice to R1. Notice to R1 is dispensed. P. Pradeep has filed a wakalat for R2. P. Pradeep, learned counsel appearing for insurance company, has contended that even though doctor has deposed that climate has suffered 11% whole body disability, tribunal, considering that the evidence of doctor and medical records and considering that the age and avocation of the climate, has rightly assessed whole body disabilities 8%. He further contended that even though climate has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 9,000 per month. He further contended that considering that evidence of doctor and medical records, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 1/8/2019 due to rash and negligent driving of driver of motorcycle bearing registration number KA 64L3881. Due to that accident, claimant has suffered the following injuries extract. The claimant has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered 33% disability to particular limb and 11% to whole body. Considering that evidence of doctor and medical records and age and avocation of the claimant, I am of the opinion that whole body disabilities can be assessed 11%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under other circumstances, notional income can be assessed considering the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, notional income has to be considered as 12,500. 19. 2019, 14,000. At the time of the accident, what is his age, Mr.?
37 years, madam.
Claimant was aged about 37 years. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows.
14,000 to 12, 15 to 11%, 2,77,200.
Due to the accident, claimant has suffered the above said injury. He was inpatient for a period of 5 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 9,000 to 40,000. Loss of income during the later period has to be granted for 2 months. Loss of immunities has to be enhanced from 15,000 to 30,000. Compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Number 80, Vishwanath R. Hegde for appellant, matter.
Same liability not has been connected. But we should take notice not in the connected matters. For appearing.
Yes.
I mean, permitted to serve copies. One is the Subhash Chandra Bose appears for respondent number 1 and
Now that Subhash Chandra Bose is directed to take notice for R1. Venkatanarayana BS is directed to take notice for respondent number 2, serial number 18.
I mean, permitted to serve
Alternate counsel for the appellant is directed to serve appeal memo to the respective counsels.
Vijay Kumar for appellant. Number 90.
Inclined. Notice issued to the respondent number 1 and 2. Written with post structure unclaimed. Yeah, one. Written with post structure unclaimed. Then service of notice to 1 and 2 is held sufficient. Yes.
Number 20, Vijay for appellant.
Furnishing a PF issue notice to R1 for second time. Posters are insufficient address. Yes, week's time is granted to do the needful. Interim order granted earlier is extended till next date of it.
Number 21, Vijay for appellant.
for applied malady. Insurance company had deposited malady payment.
Copies of having deposited remaining amount you have deposited. What is that remaining? Huh?
They have deposited malady amount. Remaining amount malady. 31,000 is there. Interest
Just deposit ಮಾಡಿದ್ದೀರಾ?
deposited.
Huh?
Along with interest malady. We deposited.
Balance amount to be deposited is 403. ಮಾಡಿದ್ದೀರಾ 400 ರೂಪಾಯಿ. ಅದು ಮಾಡ್ಬೇಕಲ್ರಿ. Yes. Week time is granted to deposit remaining amount payable to the petitioner before the trial. Huh? ಎಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ? You first deposit the 403, then we'll pass an order. Yes.
Number 22, Telecast and for appellant, Padmaja BS.
Case of injury.
Hmm.
They are the disability head, it has to be considered.
Who is Padmaja? Huh? Next week.
28th.
Yes. The request of respondent number 2, release this matter next week. Next Thursday. Yes.
Prakash MM for appellant, Liberty General Insurance.
Yes.
Number 23, Prakash MM, MH.
Liberty General Insurance ಯಾರಿದ್ದೀರಾ? You are there. P. Pradeep is directed to take notice for respondent number 1. Respondent 2 ಏನಾಗಿದೆ? Yes. Notice to R2 is dispensed. Yes.
Number 24, Sharadamba AR for appellant, C. Shankar Reddy.
Hmm. Ready, Mr. Reddy? Yes. Very great.
Taken the income as 12,000. 2019 accident and the 50% is going to a
Wait. There is a delay of 42 days in filing an appeal. IA1 of 2023 is filed for condonation of delay. There is that affidavit. For the reason stated in the accompanying affidavit, delay of 42 days in filing an appeal is condoned. IA1 of 2023 is allowed. Yes. 2019. Yes.
8
Hmm.
They're in hospital for 10 days.
Hmm.
12,000.
Disability is 6% and 30%. Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunities. Loss of income during the later period. 10,000 ತಾಂಡಿದಾರ. 1 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ. Punishment, attendance charges. Immunities ಕೊಟ್ಟಿಲ್ಲ. Immunities ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ? Yes. Yes. Interest 6%.
The 23% was equally.
Hmm.
That's how that number.
Yes. Yes, that's all.
It is just.
Nothing, not. Yes. So also, Learned Council appearing for claimant has contended that at the time of the accident, he was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 12,000 per month is on lower side. Secondly, she has contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Reddy, Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 12,000 per month. He further contended that considering that injury suffered by the claimant, considering that medical records produced by the claimant as wound certificate exhibit P6 and discharge summary, that compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 14/7/2018 due to rash. 19. Yes, 19. 14/7/2019 due to rash and negligent driving of driver of Tata Suma bearing registration number KA01 AC 0427. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed, considering that guidelines issued by Karnataka Legal Service Authority for the accident occurring in 2019, notional income has to be considered as 14,000. Tribunal has rightly assessed whole body disabilities 30%. At the time of the accident, he was aged about 41 years. The multiplier applicable to the age group is 14. Accordingly, loss of future earning has been reassessed as follows. 30%.
14,000.
Allah, disability 10%, Allah? 10%. 10, yes. Rightly assessed whole body disability is 10%.
10%, 2,35,200.
Due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 30,000 to 45,000. Loss of income during the later period has to be granted for 3 months. Nourishment attendance charges has to be enhanced from 2,000 to 10,000. Compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Number 25, Sundararaman Nimi for appellant, MS Rajendra.
Serial number?
25. sir.
And for the appellant, there is some urgency. The answer for the case been argued.
Password. ಅಷ್ಟೇ ಅವ್ರದ್ದು ಮಾತ್ರ ಪಾಸ್.
Number 26,
ಎಸ್ ಪಾಸ್ವರ್ಡ್. I don't know. I don't think password will reach or not. Password is password. What? Yes.
Number 27, Ranjagora Enna for appellant, P. Pradeep.
Appellant for appellant counsel.
Yes.
Point number 1.
Yes.
Owner of the vehicle contain notice will be dispensed.
Notice to R1 is dispensed. Yes.
LCR because
Back LCR. Huh? Office is directed to secure original records from the tribunal.
Number 28, V. P. Sitaramaya for appellant.
Pradeep may be directed to take notice. Wait
Yes.
notice. Is there
The net counsel for the appellant has filed a memo seeking dispensation of notice to R2 and R3. Notice to R2 and R3 is dispensed. B. Pradeep is directed to take notice for respondent number 1. Yes. Next week. Next week.
Bill number 29, SBI exam for appellate.
The office objection is my lord.
Hmm.
Not the tendency. So that in the judgment, Kumar, yes, in this book of respondent number 2. But yes, yes, sir. Please, name of secretary. Kumar, yes, and then it's not there. As per the award of my lord, Kumar, yes. Then small mistake is there, my lord, it may kindly be approved.
ಯಾರ್ದು ಟ್ರಿಬ್ಯುನಲ್ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
The award is not presented.
ಕುಮಾರ್ ಎಸ್ ಚಂದನ್.
But in the context of the judgment,
Hmm.
Kumar, yes, Chandan are.
ಇದರಲ್ಲಿ
Kumar, yes.
ಎಸ್ ಇದ್ರಲ್ಲಿ ಏನು ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಆ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ರು ಅಂತ.
The award, the office says, but ಎರಡೆರಡು ಆನ್ಸರ್ ಆಗ್ತಿದೆ. Kumar, yes, ಮತ್ತೆ Chandan are ಇರೋದು.
6 ಇರಕ್ ಚಾರ್ಜಿಲ್ಲ, ಏನ್ ಟೈಪ್ ಮಾಡ್ತಾರ ಏನ್ ಮಾಡಿ. Submission of learned counsel for the appellant in respect of office objection. ಅದು ಒಂದೇನಾ? Office objection is accepted. Office objection is overruled. Issue notice. Delay is there.
73 days.
Yes. Or issue notice. Stay of judgment and award dated 4th May 2023 passed by MECT Chamarajanagar in MEC 303 of 2020 is subject to appellant deposit 50 entire compensation amount. Delay ಇದೆ. ಅಲ್ಲ ಡಿಲೇ ಇರೋ ಕೇಸಲ್ಲಿ ಐ ಆಮ್ ಡೈರೆಕ್ಟಿಂಗ್ ಟು ಡಿಪಾಸಿಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ only. Yes. Subject to condition. Appellant has to deposit entire compensation amount with interest before this court within 4 weeks from today. ಇಲ್ಲಿ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಇದೆ. What is that office objection?
General insurance company.
Office objection, appellant insurance company name to be correctly stated. Counsel submission with regarding the office objection sealed affects to the wakalat does not tally with the name of the cast title of the appeal memo. ಏನು appeal memo ಯಾವುದು ಕಾಸ್ಟ್?
ಕರೆಕ್ಟ್ ಅಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ HDFC ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್
ಯಾವ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ?
HDFC ಅರ್ಗೋಜ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂತ ಆಗಿದೆ, ಬಟ್ ಅವರ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ ಜನರಲ್ ಅಂತ ಸೇರಿಸಿದ್ದಾರೆ.
HDFC ಅರ್ಗೋ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಿಮಿಟೆಡ್ ಅಂತಾನೆ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲೂ ಹಂಗೆ ಇದೆಯಲ್ಲ. HDFC ಅರ್ಗೋ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಿಮಿಟೆಡ್.
ಇನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಜನರಲ್ ಅಂತ ಸೇರಿಸಿದ್ದಾರೆ.
HDFC ಅರ್ಗೋ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್
ಅಲ್ಲ, ಅದು ವಕಾಲತ್ ಸೀಲ್ ಅಲ್ಲಿ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಇದ್ದಿದೆ, ಅದಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. Submission. Since the trial court is wrongly describing by the claimant that the response name is seal is not telling, therefore the name will only be accepted. Yes, submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is overruled. Clear? You are appearing for whom?
ಕ್ಲೈಮೇಟ್
Claimant. You will take notice. Notice ಆಗಿದೆಯಾ? Kevetar ಆಗಿದೆ. You are appearing for whom, Mr. Kevetar R1? Yes.
Yes.
Office objection is overruled. Issue notice. Shri Putswami.
accepted.
Putswami ಯಾರು? ಅಡ್ವೊಕೇಟ್ ತಾನೆ?
Advocate also.
Yes.
Advocate.
Advocate, the counsel appearing as an caveator is accepted. Notice to R1. Issue emergent notice to R2 and R3. PMTC ಇದಕ್ಕೆ ಮಾತ್ರನಾ ಏನ್ ಸ್ಟೇ ಕೇಳಿದ್ದೀರಾ? You are seeking for stay. Stay of judgment and award dated 10th August 2023 passed by MECT Bangalore in MEC 1194 of 2021 subject to deposit 50% of the award amount with interest before this court within 4 weeks.
Number 31, for appellant.
Yes, ma'am. Total award, my lord. 30,48,962 in page number 26 of the judgment, my lord. High Court judgment.
Counsel submission with regarding to the office objection. Total award amounts differ from page number 26.
30,48,962, my lord.
Yadralli?
By page number 26, my lord. Total
26 of what?
High Court judgment. 13,48,962 ಕೊಟ್ಟಿದ್ದಾರೆ. By mistake and oversight, my lord, page number 31. 12,24,000 ಅಂತ. Typographical mistake, my lord.
12,24,000 loss of income due to the permanent disability. ಹಾಕಿದ್ದೆಲ್ಲ ಸೇರಿ 13 lakhs ಆಗುತ್ತೆ. ಇವ್ರೇನ್ ಮಾಡಿದ್ರೆ petitioner MEC is entitled to compensation.
MEC, my lord, 2289 of 2021.
Without mistake, no judgment has been pronounced by that.
Order portion ಅಲ್ಲಿ
ಎಲ್ಲಾ judgment ಅಲ್ಲೂ ಒಂದಲ್ಲ ಒಂದು there is an error. Yes. ಅದು ಒಂದೇನಾ? Number ಎಷ್ಟಿದೆ? Submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is overruled. Issue notice.
Number 32. Whichever for appellant.
Usually, there is a mistake on the part of the trial court on 1/3/2013 instead of 2/12/2011, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
Usually, page number 10, my lord. So the petitioner proved that the road accident occurred based on 1/3/2013 and there is a mistake on the typographic error.
ಯಾವತ್ತು ಅದು ಆಕ್ಸಿಡೆಂಟ್?
Accident has happened 23/12/2011, my lord.
Yes. Submission of learned counsel to the appellant in respect of office objection is overruled.
Petition, my lord.
Office objection is overruled. Yes. What is this, mister?
Case is that he was plowing and disease was plowing and mudguard of the tractor, my lord.
Yes.
You are challenging the liability.
Issue notice. Stay of judgment and award dated 29th March 2023 passed by MECT Krishnarajpet in MEC 1014 of 2013 subject to appellant deposit entire compensation amount with interest before this court within 4 weeks.
Number 33, for appellant.
Deposited award remaining about 31,000 when I paid the delivery. 31,242 rupees is remaining about.
One up? Why? But to file an appeal, you have to deposit now. Then remaining amount you have to deposit.
2 weeks may be taken.
Yes. 2 weeks time is granted to comply that of subjection.
Deposited upon the way.
What is this matter? On what ground you are challenging it? On what ground you are challenging? Why? What is the tribunal said?
is was working as a driver under the fourth respondent, he was working. Well, there are retention of the while appellant is known.
Difference amount ಎಷ್ಟಿದೆ?
31,000, 31,240.
Balance amount to be deposited 32,000, mister. Yes. Or issue notice. Day of judgment and award dated 28th February 2023, passed by Senior Civil Judge Madikeri in ECA number 4 of 2019, subject to condition appellant has to deposit balance amount of rupees 32,666 before the tribunal within 2 weeks from today. Permission original certified copies for depositing the criminal.
Matter, serial number 34, Rajshekar as per appellant, connected matter, Manjunath ND.
I for petition.
Who is that other side?
Manjunath ND,
Yes. Hearing post ಆಗಿತ್ತಾ ಇದು?
Last time post ಆಗಿತ್ತು ಅವ್ರು ಬಂದಿಲ್ಲ.
Yes, none appear. Leave this matter of 2 weeks. None appear for the respondent. Leave this matter of 2 weeks.
number 35, Rajshekar as per appellant,
Petition of delivery that statement.
What is this matter, mister? On what ground you are challenging? No, why you are challenging enhancement? Yes, sir. This.
Petition of compensation. Point limit.
Yes. You not justify in holding the driver of the bus is. There is a delay of 36 days in filing an appeal. IA 1 of 2020 is filed for condonation of delay. Respondent served unrepresented. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 36 days in filing an appeal is condoned. IA 1 of 2020 is allowed. Yes, heard, admit.
number
Bharat.
36, G. Lakshmi Shah for appellant, Sangamesh SS.
Yes. Yes, ready, madam.
Challenge 100% negligence in this.
Hmm.
And we have deposited 100% before the honorable court lordship.
Hmm.
And out of that amount, 1,50,000 may be released. Since I have challenged both quantum and negligence.
What is that amount which is awarded by the tribunal?
It is 4,69,000. 4,69,200.
Case of injury, na?
So, injury.
You can give 50% before installment. It's like 89.
Basic requirement is like quantum of release the deposit.
Here, honorable court order, we deposited 50% before the tribunal lordship.
Where you have deposited?
Before tribunal, before passing this honorable court order, white check number 002497. I have filed.
Permitted to avail, revalidated the demand draft and represent the same before the registry. He is permitted to collect and we have represented the same.
I have filed memo.
When?
Filed on 9th November 23.
23.
9th November 23.
Deposit eligible.
ಏನು ಬರ್ದಿಲ್ಲ ಕೇಳ್ತೀನಿ ಸರ್. ಯಾಕೆ ಇದು ಪೆಂಡಿಂಗ್
ರಿಲೀಸ್ ಅಮೌಂಟ್ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲಿ ವೇರ್ ಯು ಹ್ಯಾವ್ ಡಿಪಾಸಿಟೆಡ್ ನೋಡ್ರಿ ಸರ್.
Tribunal wide check.
ಟ್ರೈಬ್ಯುನಲ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ, ಬಟ್ ಇಲ್ಲೊಂದು ಅದೇ ಹಾಕಿದ್ದಾರೆ ರಿಟರ್ನ್ ಇಲ್ಲಿಗೆ ಇಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ ಅಂತ. 1/22 ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಅಮೌಂಟ್ ಅಲಾಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಇವರು ಕೇಳಿದ್ರು ಟ್ರಾನ್ಸ್ಫರ್. How much you have deposited now? 2,89,000.
So deposited 50% hardship. 50% on the reported. Like that.
Why you have deposited like that?
Before passing this honorable court order hardship, we have already deposited by mistake.
No, where is that this court order directed you to deposit? There is no any order.
Mentioned in my memo hardship.
19/4. ಯಾವತ್ತು ಡೇಟ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ 19/4/2021. Heard on IA, there is that affidavit for the support being satisfied.
Entire
Is into judgment subject to that appellant deposit entire amount with interest before this court within 4 weeks from today.
hardship by mistake on appellant. This order we already deposited before the tribunal. And I have completed this honorable court.
No, sir, you have deposited entire amount before the tribunal.
50% before the tribunal, 50% before this one.
$2,89,000 plus 25,000.
Yes, 2 lakhs is here. Will permit that amount to be released.
I have challenged both quantum and negligence hardship.
Hmm.
Out of that, 1,00,000 may be released because there is no vicarious liability on the part of KSITC hardship.
Yes.
It's the wrongdoer's liability.
Senate Council for Respondent Climate has filed IA number 4 of 2023 for releasing that amount deposited by the appellant before this court. There is that affidavit for the reason stated in that accompanying affidavit. IA 4 of 2023 is allowed. The climate respondent is permitted to withdraw 1,50,000 deposited before this court by the appellant. Registry is directed to release 1,50,000 in favor of the climate after the verification. Yes. First, Amal not an S. IA 1 of 2023 is dismissed as not pressed. We deposited the remaining memo filed by the appellant for having deposited remaining 50% of the award amount before the tribunal instead of before this court is accepted. Ready? Yes, Mr. Girish.
28th maybe.
Yes, there is a delay of 109 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. For the reason stated in that accompanying affidavit, delay of 109 days in filing an appeal is condoned. IA 1 of 2021 is allowed. Pause this matter next Thursday.
28th.
Yes.
Number 38, Vijay Kumar T for appellant, C. Shankar Reddy.
Ready?
Injury for enhancement.
Hmm.
Main the time of the accident, injured about 16 years.
Yes.
The doctor assessed 50%.
50. ಎಲ್ಲಿದೆ? Yes.
Not educated, but the purpose of assessing the eligibility has been examined.
Yes.
Whole body 50% assessed.
Yaro.
Actor, page number 20, para 23.
Read.
Discussion. What are to the age 12? Page 12. What are to prove the disablement suffered by petitioner? He has examined assistant psychological professor Jesus Hospital, Mysore, as BW3, who has stated in his evidence regarding the injuries sustained by the petitioner and the difficulties facing by him and disablement suffered by the petitioner. Further, he has stated that the petitioner has suffered disability to the extent of 50% to the whole body. Support of this evidence, the PW3 has produced the documents and same are marked as exhibit P 32 and 33 minutes.
Read for 24. Para 24 over.
Perusal of
Thereafter, counsel for the respondent number 2 has cross-examined that PW.
at length in the cross examination, the PW3 has clearly stated at page 3 and 4 that ಯಶವಂತ್ ಇವರಿಗೆ ಆದ ಗಾಯಗಳಿಗೆ ನಾನೇನು ಖುದ್ದಾಗಿ ಚಿಕಿತ್ಸೆಯನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಜೊತೆಗೆ ಗಾಯಾಳುವಿಗೆ ನ್ಯೂರೋ ಸರ್ಜನ್ ಆದ ಡಾಕ್ಟರ್ ಬೋಪಯ್ಯ ಇವರು ಚಿಕಿತ್ಸೆ ನೀಡಿದ ಬಗ್ಗೆ ನನಗೆ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಗಾಯಾಳು ಯಶವಂತ್ ಇವರು ಅವರಿಗೆ ಆಗಿದ್ದ ಗಾಯಗಳಿಗೆ ಪೂರ್ಣ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡು ನಂತರ ಅವರಿಗೆ ಇರುವುದು ಎಂದು ಹೇಳುವ ನ್ಯೂನ್ಯತೆ ನಿರ್ಧರಿಸಿಕೊಳ್ಳಲು ಮಾತ್ರ ನನ್ನ ಬಳಿ ಬಂದಿರುವುದು ಎಂದರೆ ಸರಿ. ಡಿಸ್ಚಾರ್ಜ್ ಪತ್ರದ ಪ್ರತಿಗೆ ಅನುಗುಣವಾಗಿ ನೀವು ನ್ಯೂನ್ಯತೆ ನಿರ್ಧರಿಸಿರುವಿರಿ ಎಂದು ಸೂಚಿಸಲಾಗಿ ಸೂಚನೆ ಸರಿಯಲ್ಲ. ನಾನು ಡಿಸ್ಚಾರ್ಜ್ ಪತ್ರದಲ್ಲಿಯ ಅಂಶಗಳನ್ನು ಮತ್ತು ಗಾಯಾಳುವನ್ನು ಕ್ಲಿನಿಕಲಿ ಪರೀಕ್ಷಿಸಿ ನಂತರ ಸೈಕಾಲಜಿ ವರದಿ ಪಡೆದುಕೊಂಡು ಆ ನಂತರ ನ್ಯೂನ್ಯತೆ ನಿರ್ಧರಿಸಿರುವೆ ಎಂದು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾರೆ. ಗಾಯಾಳುವಿಗೆ ಇರುವುದೆಂದು ಹೇಳುವ ನ್ಯೂನ್ಯತೆಯನ್ನು ನಾನು ಕೇಂದ್ರ ಸರ್ಕಾರದವರು ಹೊರಡಿಸಿದ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ಗೆ ಅನುಗುಣವಾಗಿ ನಿರ್ಧರಿಸಿರುತ್ತೇನೆ. ನಾನು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿದಂತೆ ಗಾಯಾಳು ಯಶವಂತ್ ಇವರಿಗೆ 50% ನ್ಯೂನ್ಯತೆ ಇರದೇ ಇದ್ದರೂ ಕೂಡ ಅದನ್ನು ಉತ್ಪ್ರೇಕ್ಷೆಯಿಂದ ನಿರ್ಧರಿಸಿ ಹೇಳಿರುವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗಾಯಾಳುವಿಗೆ ಇರುವುದೆಂದು ಹೇಳುವ ನ್ಯೂನ್ಯತೆಯ ಪ್ರಮಾಣವು ಆತನ ಎಡ ತಲೆಯ ಭಾಗಕ್ಕೆ ಮಾತ್ರ ಸಂಬಂಧಿಸಿದಂತೆ ಇರುವುದು ಎಂದರೆ ಸರಿ.
On perusal, what is that conclusion of the, yes. What is that? Read further.
On perusal of the above evidence of PW3, it clearly goes to show that the PW3 is not a treated doctor and he has only assessed the disability suffered by the petitioner. Further, on perusal of evidence of PW3, it reveals that the extent of disability suffered by the petitioner, particular part of the body, yet within bracket of the petitioner. Considering the above facts and looking to the nature of injuries sustained by the petitioner and looking to the age and the status of the petitioner, and for the above reason, I am of the opinion that if 50% of the disability of a particular limb is considered as a disability to the whole body, then it comes to 25% and the same is considered as disability to the whole body. Certainly, it needs the sense of justice and hardship for the.
Yeah, where is that doctor evidence? Doctor evidence idea?
Yes.
ಏನು ಡೀಟೇಲ್ಸ್ ಏನು ಹೇಳಿಲ್ಲ. ಅದು ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಸೈಕಾಲಜಿ ಅಂತ ದಟ್ ಆಯ್ತ್ರಿ. ಅವರೇ ಬಂದು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ PW1 1/3 ಬರಲ್ಲ but he himself has given evidence. If that neurological injury, if it is so serious, he could not have enter the witness box. He has appeared to that witness box and has given evidence. Cross examination uttara kottidare nim client. One third neurology 50% disabilities ide andre can he enter into that box and answer? Haudalla? Neurological disabilities ಗೆ ನಿಮಗೇನು one third ಅಸೆಸ್ಮೆಂಟ್ ಮಾಡಕ್ಕೇನು ಇಲ್ಲ. ಅದ್ರಲ್ಲಿ 50% 1/3 ತಗೋಬೇಕಂತ ಇಲ್ಲ. ಬಟ್ ಸಿ ದ ಸಿಚುಯೇಷನ್. One, he is the doctor, he has not treated, he has examined, yes. But the very same patient who has appeared before that court and he has given an examination, chief examination alla answer ಮಾಡಿದ್ದಾರೆ. If he is no, that who has then father, he has not been he is a minor. Then
judgment my lordship.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
What disability 3 lakh ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡಿ
60% 4 lakh ಕೊಡ್ತಾರೆ.
ಎಷ್ಟು ಅದು? 30% ಗೆ ಎಷ್ಟಿದೆ?
30% ಗೆ 3 lakh.
5 lakhs ಎಷ್ಟಿಗಿರೋದು ಅದು?
90% 5 lakhs. Up to 60% my lordship 4 lakhs.
ಮತ್ತೆ ನಿಮ್ ಡಾಕ್ಟರ್ 50% ತಗೊಂಡ್ರು ಅಷ್ಟೇ ಬರ್ತದಲ್ಲ. Even if you take that 50% also, it is a 3 lakhs. I thought that above 30 lakhs ಜಾಸ್ತಿ ಇದೆ ಅಂತ. Then it's correct. ಬೇರೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Medical expense my lordship 91,000. Paid up period parents my lordship for 21,000. 7,000 considered.
Wait. I will come to that.
600 in the year 2017.
Wait. Disability about 10%, up to 30%, up to 30%, 3 lakhs. Up to 60%, no, up to 60% it is 4 lakhs. Above 60% to 90%. With the disabilities is 10%. Up to that chart. If the disabilities is above 10% and up to 30% to that whole body, 3 lakhs. Up to 60% it is 4 lakhs. Huh? Right. ಇನ್ನೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
Finance of 35,000. It is so 25,000. Attendance charges my lordship 5,000 awarded.
First medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ.
91.
Discomfort, conveniences, loss of earning, parents during 25,000. Medical incidental expenses during the period of hospitalized 25. Future medical expenses and corrections of that. ಅದು 75. ಅಷ್ಟೇ ರೀ. 4 ಲಕ್ಷ ಕೊಟ್ರು ಅವ್ರ ಅದರ್ ಹೆಡ್ ಅಲ್ಲೆಲ್ಲ ಬರೋಲ್ಲ ಅಲ್ಲಿ. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗು ಎಲ್ಲಾ ಸೇರಿ ಅದು 3 ಲಕ್ಷ ಅದು ಅವ್ರು ಹೇಳೋದು. ಈಗ ಇಫ್ ಐ ಇನ್ಕ್ರೀಸ್ ದಟ್ 4 lakhs ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಒಂದು 91, 5 lakhs ಆಯ್ತು. ಇನ್ನೊಂದು 25-30 ಸಲ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ವಿಲ್ ಮೇಕ್ ಇಟ್. ಇದರಲ್ಲಿ that will be taken as a 50%. It will become 4 lakhs. ಆಯ್ತಾ? 4 lakhs ಆದ್ಮೇಲೆ 25,000 loss to that parents. ಮೆಡಿಕಲ್ ಅಂಡ್ ಇನ್ಸಿಡೆಂಟಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ನಿಮ್ದ್ರಲ್ಲಿ 91 ಆಗಿದೆ. 1 ಲಕ್ಷ ತಗೊಳ್ಳಿ. 4 1 5 5,25,000. Future medical expenses. ಅಷ್ಟೇ ಬರ್ತಾ ಇದೆ, ಹೇಳ್ತೀನಿ ತಡ್ರಿ. 4 1 5 5,25,000 ಮತ್ತೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ 25 5,50,000. ಇಲ್ಲಿ 4,75,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಲ್ಮೋಸ್ಟ್ ಸಿಮಿಲರ್. Yes, we'll make it that same thing. Yes, 4 lakhs, 5,25,000 wholesale. Kali. So and so, learned counsel appearing for the claimant has contended that due to that extent, claimant has suffered grievous injury to his head. He has examined doctor as PW3. In his evidence, he has deposed that claimant has suffered to the extent of 50% to whole body. Since disability suffered by the plaintiff, the claimant is neurological disability. The tribunal error in held that disability has to be assessed only at 25%. He contended that if disability has to be assessed 50% in view of judgment of apex court in case of Master Mallikarjun, the compensation is required to be enhanced. For contra, Sri Reddy learned counsel appearing for insurance company has contended that even though doctor has assessed disability 50% to whole body, he is not a treated doctor. On the basis of the medical records, he has assessed disability. The tribunal, after considering that evidence of the doctor and injury suffered by the claimant, has rightly assessed whole body disability 25%. Considering the judgment of apex court in case of Master Mallikarjun, the overall compensation awarded by the tribunal just and reasonable. The interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Rose, judgment and award. It is not in dispute. What is his name? Yashwant suffered an injury in a road traffic accident occurred on 4/11/2016 due to rash and negligent driving of rider of motorcycle bearing registration number KA 55 V8824. At the time of the accident, claimant was aged about 16 years. He was student. Due to that accidental injury, he sustained severe head injury. The doctor, what is the name of the doctor, Mr.?
Yes, sir. Kashyap.
ಏನು PW3 ನಾ?
PW.
ಡಾಕ್ಟರ್ ಋತ್ವಿಕ್ ಎಸ್ ಕಶ್ಯಪ್, assistant psychological professor, JSS Hospital, Mysore, has been examined as PW3. In his evidence, he has deposed that the claimant has suffered disability to the extent of 50% of that whole body. Since The claimant has sustained severe head injury. Therefore, whole body disabilities has to be assessed 50%. In view of judgment of apex court, in case of Mallikarjun versus Divisional Manager, National Insurance Company Limited and others, reported in 2013 ACJ 2445. In case of injury suffered by the minor, if disabilities is above 30% and up to 30%, up to 60%, the 4 lakhs compensation has to be awarded under the head of pain and suffering and mental and physical shock, hardship, inconvenience, and discomfort. Accordingly, the claimant is entitled 4 lakhs compensation under the said head. The claimant has spent medical expenses of rupees 91,000. Same has been awarded under the head of medical expenses. Medical expenses has been spent more than 91,000. Hence, 1 lakh has been awarded under the head of medical expenses. Medical expenses has been expenses 91,000 ಯಾಕಲ್ಲ ಮೊದಲಿನ ಹೇಳಿದ್ದು. Discomfort, inconvenience, loss of earning to the parents has to be awarded. ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ 4,91,000 ಆಯ್ತಾ? ಅಲ್ಲಿಗೆ 77 40,000 has been awarded. Discomfort, convenience, loss of earning to the parents. 40,000 has been awarded. 4 lakhs plus 91 that's 40.
5,31,000.
Correct. Yes. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The enhanced compensation amount carries 6% interest. Yes,
26.
IA 1 of 2021 is filed for condonation of delay. Peruse that affidavit. For the reasons stated in that accompanying affidavit, delay of 126 days in filing an appeal is condoned. The 3 category 4 lakhs plus 91,000 plus 30. 30 na? 3 40. 40. Only 3 head. Yes. Yes, ready.
Liability has been fixed on the owner
Hmm.
without their putting any evidence that by insurance company. can take the,
Hmm.
compromise the petition and the deposited the award.
Why that liability has been fixed on the owner?
On the ground that there is a violation of permit violation.
In connected matter, they have paid.
Paid
Yes,
compromise.
mister.
Compromise. Otherwise, the evidence setting ಮಾಡಿಲ್ಲ.
No, that in same accident, in respect of involvement of the same vehicle, in one case you said that yes, I am liable. You can't say that other case you are not liable.
ಇಲ್ಲ. Insurance no. Like tribunal member himself is disputed.
ಅಲ್ಲ ಅದು ಬೇರೆ ಬೇರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಇಲ್ಲ ಒಂದೇ ಜಡ್ಜು ಸೇಮ್ ಅಂತೆ. ಜಡ್ಜು ಸೇಮ್ ಅಂತೆ.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಅವ್ರ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಹಾಕಿದಾರಾ?
ಇನ್ಶೂರೆನ್ಸ್ ಲಯಬಿಲಿಟಿ ಮಾಡಿ ಅವ್ರು ಕಟ್ಟಿದ್ದಾರೆ ದುಡ್ಡು.
Yes, mister. Which is that other case?
MEC 6/2016 and 6/2016.
Yes. What is that on 2020 about climates and his daughter by name? Visited to the Pavagada. After their work, they were returned from the Pavagada place. The driver of the auto was following the traffic rules when the petitioner and his daughter passenger were reached near the Romanelli guest Pavagada. Very good. Said the auto about autoದಲ್ಲಿ other passengers has been. How can that? Huh? That will condone, not entitled for the interest. Huh? No. We'll come to that on that point later. First, what you say about that liability? MEC you have not challenged. Then you have accepted that. How can the tribunal give a finding in one case? Huh? ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. You have accepted. Yes. ಏನು ರೂಟ್ ಪರ್ಮಿಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತನಾ? Contended that accident is sustained grievous injury, treatment hospital. Then what is this injuries? ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಷ್ಟು ಕೊಡ್ಬೋದು? Yes, mister. How much can be enhanced instead of going all this? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? We'll make it 1,50,000. 97 ಕೊಟ್ಟಿದ್ದಾರೆ. I will make it 1,50,000 with interest. 50,000. Yes. So and so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous injury. He has undergone surgery. He has spent more than 1 lakh towards the medical expenses. The global compensation awarded by the tribunal, 97,850, is on lower side. Hence, he sought for enhancement of compensation. In respect of liability, he has contended that how many claim petition has been filed? There are 3 claim petition has been filed in respect of same accident. In respect of other claims, the tribunal has held that insurance company is liable to pay that compensation. Same has been accepted by the insurance company. Under those circumstances, the tribunal is error in fostering the liability, exonerated that insurance company in this claim petition. Hence, he sought for allowing that appeal. Per contra, so and so learned counsel appearing for insurance company has contended that The injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering that medical records and wound certificate exhibit P6, the tribunal has awarded just compensation. In respect of liability, contended that since insured has violated the policy condition, the tribunal has rightly exonerated that insurance company, but he has not disputed. In respect of other claim petition, the insurance company has paid that compensation. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 12/6/2013 due to rash and negligent driving of driver of bus bearing registration number KA06D 8888. ಯಾವ್ದಕ್ಕೆ ಬಸ್ಸಿಗೆ ಪರ್ಮಿಟ್ ಇರಲಿಲ್ಲ ಅಂತ ಇದು ಆಟೋಗೆ ಪರ್ಮಿಟ್ ಇರಲಿಲ್ಲ. No, he is the insured of auto or bus. Bus ಆದ್ರೆ ಮತ್ತೆ how can that yes. Due to the accident, claimant has suffered the following injury. He has spent 1 lakh rupees for medical expenses. Considering that evidence of doctor and injury suffered by the claimant, considering that wound certificate exhibit P6 and discharge summary exhibit P8, I am of the opinion that the global compensation awarded by the tribunal 97,850 has to be enhanced to 1,50,000 with interest. In respect of liability, if liabilities is concerned, in the same accident, there are 4 claim petition has been filed. A claim petition number kodi. In 3 claim petition has been filed. In 2 claim petition, the tribunal has held that the insurance company is liable to pay that compensation. Accordingly, the insurance company has paid the compensation to the claimants. They have not challenged the same. In view of the above, the insurance company is liable to pay that compensation. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit 1,50,000 rupees with 6% interest within 6 weeks from date of 14 days. They have 314 days in filing an appeal is condoned, not entitled for the interest for a period of 314 days. Orderly, in view of order dated so and so, the claimant is not entitled for the interest for enhanced compensation amount for a period of 314 days. Yes. What is the finding of the trial court? Have you urged this contention before the trial court? Catch it. Right.
He has admitted in the hospital.
Hmm. Yes, records has come. No, for releasing the amount, we'll consider. When you are granting a stay, we are very liberal. For this, when the records comes, we can see that it can be released. Otherwise, person who has suffered, see, he might have not noticed that correct vehicle number. Before investigation, police has filed a charge sheet. If it is not your bus is involved, charge sheet has been filed. You are not challenged. See, the involvement of the bus, there is no dispute. KSRTC bus is also not dispute. Only thing is that bus number. Police has investigated. Your vehicle has been seized. You are not challenged anything. No, tomorrow somebody has come and police has come and seized your vehicle. Will you keep quiet? Unless it is not involved in any this thing. Where is the charge sheet? Where is the complaint?
This is A 19F.
ಆಯ್ತು. Oh, you was traveling in the bus.
Yes, but nothing without that. They have taken the ticket or.
Yes, Mr. Where is the ticket you are traveling? Driver are denied. You are not traveling in the bus. Where do you fell? You fell down in that bus? No, that your case is that you are inside the bus. When he put in a brake, you fell down. How can that?
Back side of the bus.
ಬಿದ್ದಾಗ ಅಲ್ಲಿ ಸುಮ್ನೆ ಬಸ್ ಹೋಗಕ್ ಬಿಡ್ತಾರೇನ್ರಿ ಜನ?
ಸ್ವಾಮಿ, ಹಿಂದ್ಗಡೆ seat ಅಲ್ಲಿ ಕೂತಿದ್ದೆ, ಜೋರಾಗಿ brake ಹಾಕಿದ್ರು ಕೂತ್ಬಿಟ್ಟೆ ಅಂತ ಹೇಳಿ.
ಬಿದ್ದಾಗ ಬಸ್ ಹೋಗಕ್ ಬಿಡ್ತಾರೇನ್ರಿ ಸುಮ್ನೆ?
ಸ್ವಾಗೆ ಇದ್ರೆ ಹಿಂದ್ಗಡೆ seat ಅಲ್ಲಿ ಕೂತಿದ್ದೆ.
ಅಲ್ರಿ ಇಂಜುರಿ ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ, ನೀವು ಬಸ್ ಅಲ್ಲಿ ಹೋಗ್ತಿರ್ಬೇಕಾದ್ರೆ ಟಿಕೆಟ್ ತಗೋಬೇಕು ತಾನೆ? ಆಯ್ತ್ರಿ, ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಬಸ್ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಫಸ್ಟ್ ಟಿಕೆಟ್ ಇಟ್ಕೋಬೇಕು ತಾನೆ? ಬಸ್ನವ್ರು ಒಬ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಎಲ್ಲಿಂದ ಬಿದ್ದೋದ್ರಿ? ಇದು ಯಾವ್ದೋ ಓಪನ್ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಎಲ್ಲಾರು ಹಿಂದ್ಗಡೆಯಿಂದ ಬಿದ್ದೋದ್ರೆ ಗೊತ್ತಾಗೋದಿಲ್ಲಲ್ಲ, ಹಂಗಾಯ್ತು. ನೀವು ಬಸ್ ಒಳಗಡೆಯಿಂದ ಕೆಳಗೆ ಯಾರ ಬಿದ್ರೆ ವಿತೌಟ್ ಸ್ಟಾಪಿಂಗ್ ದ ಬಸ್, ಕೆನ್ ಯು ಮೂವ್? Who will allow that vehicle to move, mister?
ಹಿಂದ್ಗಡೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ, ಹಿಂದ್ಗಡೆ ಬಸ್ಸಲ್ಲಿ ಹಿಂದ್ಗಡೆ seat ಅಲ್ಲಿ ಕೂತಿದ್ದೆ.
ಆಯ್ತ್ರಿ, ಬಿದ್ದಾಗ ಯಾರೋ ಪಕ್ಕದಲ್ಲಿ ಇದಾರೆ, ಯಾರೋ ಬಿದ್ದೋಗಿದಾರ್ರಿ, ಬಸ್ ನಿಲ್ಸಿ ಅಂತ ಹೇಳಲ್ವಾ? ಯಾವ ಊರಿದು?
ಅದಕ್ಕೆ ಸ್ವಾಮಿ ನಾವು
ವಿಚ್ ಪ್ಲೇಸ್?
after 11 days ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Yes.
And he says he has taken internal treatment ಅಂತ.
In fact, driver and conductor has denied everything. We don't know any somebody is traveling and accident, sir. Matter request. We'll see. We'll have it there first week of January. Even, huh? I will dismiss your application for, there is no cases made out. ನೀವು ಬಸ್ ಅಲ್ಲಿ ಹೋಗ್ತಿದ್ದೀರಾ ಅನ್ನೋದೇ ಡೌಟ್ ಬರ್ತಾ ಇದೆ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಎಸ್ಟಾಬ್ಲಿಷ್. ನೀವು ಅಡ್ಮಿಟ್ ಆಗ್ಬೇಡಿ ಬಿಡಿ. ಫಸ್ಟ್ ಯು ಶೇ ದಟ್ ವೆದರ್ ಆಕ್ಸಿಡೆಂಟ್ ಹ್ಯಾಸ್ ಅಕರ್ಡ್ ವೆನ್ ಯು ಆರ್ ಟ್ರಾವೆಲಿಂಗ್ ಇನ್ ದಿಸ್ ಬಸ್. I thought that when you are going, some bus has dashed you, but it is show that you are inside the bus, one of the passenger. That on the prima facie it appears matter request. Yes, please this matter first week of January 2024. Yes.
For opponent, connected matter, Kumara KG.
Yes. Yes. There is a delay of ಕೊಡಿ. ಯಾರಿಗೆ ನೋಟಿಸು? ಅಲ್ಲ, ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 1 ಪ್ರೂಫ್ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? 2 ಯಾರೋ ಇದಾರಲ್ಲ. Yes. Kumar KG is undertaken to appear for respondent number 1. Office is directed to show his name. There is a delay of 80 days in filing an appeal. IA 1 of 2022 is filed for condonation of delay. Peruse that affidavit. For the reason stated in the accompanying affidavit, delay of 80 days in filing an appeal is condoned. IA 1 of 2022 is allowed. What about second matter? Only he will take notice for cases. Three, the Lakshmish Rao G. ಎರಡನೇ matter ಅಲ್ಲಿ directed to take notice for respondent number 2. ಅವರು ಶ್ರೀನಿವಾಸ್ ಯಾರದು? ನೀವ್ಯಾರಿಗೆ? GR Srinivas ಯಾರ್ರಿ? GR Srinivas for R2 ಅಂತ ಇದೆಯಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ R2 ಯಾರು? ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್. ಇನ್ ಕೇಸ್ ಅಲ್ಲಿ ಜಯರಾಗಯ್ಯ is the respondent number 1. Yes. GR Srinivas is directed to take notice for respondent number 1. T Lakshmi Rao for R2. Aikalali service. Yes. What is your case? On what ground they have filed? Yes. ಅದು ಎರಡನೇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಲ್ಲ. There is a delay of 109 days in filing an appeal. IA 1 of 2023 is filed for condemnation of delay. Peruse that affidavit for the reasons stated in that accompanying affidavit. Delay of 109 days in filing an appeal is controlled. Yes. Heard? Records ಬೇಕಲ್ಲ. Office is directed to secure original records.
There is no nexus between accident and injury. Right?
Yes, we'll see that records. Yes.
Number 42, be ready for appellant, connected matter, Mallikarjun.
Yes. Huh? Ready?
Application for release of amount.
Release of amount. Yes. You are challenging liability. Why? Passengers traveling in goods vehicle. What is the finding of the tribunal? Para number?
12.
Yes, read.
Exhibit R2. These are the insurance policy and provision of the same. It disclosed that it is a package.
Package policy. Seating capacity was 2 in number. 2 in number ಅಂತ ಐತಲ್ರಿ? Huh? That when the accidents occur in deceased along with the driver who are only a person traveling in the auto, that being the situation, it's a goods vehicle. Goods vehicle.
Exhibit T13 documents which are
Risk of the passenger will not cover since he was the owner of the goods and that the respondent had not paid the additional premium or liability. But when the license seating capacity has been mentioned too, habitually there are only totally 2% driver and the deceased traveling in the said vehicle. Okay, the insurance company cannot make any fine distinction to wringing out its liability by stating that risk of the passenger was not covered. No, the seating, you have said that 2 persons can be traveled. Other than that, owner of the goods, he need not 2 persons who has been permitted. They need not be a owner of the goods, is it not? That will permit him to withdraw. Next week, let us see. Yes, anyhow, subject to that result.
I have produced exhibit T13 documents which are going along with goods, onion millers. I have produced the documents.
I will see that now. We'll permit it to withdraw. H, how much amount has been awarded?
5 lakhs, 84.
In case of injury and death.
Yes.
Death. Who are the claimants?
First claimant is the wife of the teacher, and second claimant is the brother of the teacher.
Brother.
5,72,922.
Third.
Second one, one Paratama was died during pendency of the claim petition. Only 2 claimants.
Yes. 6% realized the respondent number 2 deposit the award amount within so and so appropriate made after deposit.
ಅಪಾರ್ಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ
Apportionment ಏನು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
Yes. ಎಷ್ಟು 5 ಲಕ್ಷ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರು.
5,72,922 they have deposited before this honorable court.
Yes. Will permit it to withdraw 4 lakhs. 4 lakhs, 4 lakhs. Yes. IA 3 of 2023 is filed by the climate Chaitra MP, wife of the deceased, taking permission to release the amount deposited by the appellant before this court. Peruse that affidavit for the reasons stated in that accompanying affidavit and also in the interest of justice. The claimant number 1, Chaitra, is permitted to withdraw 4 lakhs rupees deposited before this court, subject to result of this appeal. The office is directed to release 4 lakhs in favor of first claimant Chaitra MP after due verification
E-payment.
through e-payment.
Serial number 43, G.B. Siddaramaiah for appellant, Janardhan Reddy.
And by denying interest, delay may can be controlled.
Yes, Mr. Will condone the delay. What are you doing for so many days, Mr.?
That page number 40, para 8 may continue.
Page number?
40, running page 40, para 8.
Yes.
Stated on 16/7/14, the Endolite India Limited has assessed that I require 4 so and so for leg fitment replacement. Due to my financial difficulties, I am unable to change the artificial leg. I have several medical records to place before the Salva court regarding the expenses required for me for my further treatment. The latest report will also be placed before the Salva court if an opportunity is given by controlling the delay caused in filing this appeal. I stated I am unable to afford for an artificial leg replacement in view of the financial difficulties. The doctor has advised in the month of April 2023 that an artificial leg needs to be replaced. Otherwise, it will lead to further medical complications due to my advanced age. I further state that the compensation awarded by the tribunal is very less and my financial and physical condition is too pathetic. Hence, I need money for continuous treatment. As stated, I have entrusted my file to one K. Indrasekhar Achar, advocate practicing at so and so. I further stated due to my financial and physical pathetic condition, I was unable to contact my advocate regularly to verify the progress of the case. I further stated on 28 August 2022, I searched the online case status through the court website in Shumaka in browsing center. On verifying the same, no such case number is reflected in the online system, reflecting the case status pertaining to my appeal. I stated thereafter I was not able to contact my High Court advocate since I lost phone number. Hence, I have requested my trial court advocate to apply for certified copy of the judgment passed by the tribunal to make inquiry with my High Court advocate. On my request, my trial court advocate has applied for the certified copy of the judgment on 30/8/2022 and has received the same on 13/9/2022. Thereafter, due to financial difficulties and my pathetic physical condition, I was unable to come to Bangalore. As I alone cannot come as I have to be accompanied by other person physically. I stated with great difficulty after arranging money by raising loan, I came to Bangalore on 13/4/2023 along with one of my friends. On verification, I came to know that my earlier advocate, so and so, has explained long.
Earlier advocate ನೀವು ಯಾವಾಗ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲಲ್ಲ. You have not explained the date when you have approached him. Because 2009 this
Through trial court advocate, the matter was.
ಅದೇ specific date ಬೇಕಲ್ಲ. If you are approached in 2022, then who has to explain for 10 years?
From 2014 itself, we have given answer. That is in para number 8. That is the overall.
No, para number 8 is in respect of that, in respect of injury, subsequent this thing. What about that, when you have approached the advocate?
You have the condition that amputation above the knee, and you was a.
No, that your doctors knows when you have suffered an injury that what will happen in the future. You should have advised, you require replacement.
That
Then
that
the
is the,
tribunal has not awarded, you could have approached, what is the
that is the method. It was given to another advocate and.
all that you have not stated. How much tribunal has awarded?
That for amputation rupees
43,000.
689.
ಈಗ only artificial leg you are ಕೇಳ್ತಾ ಇದ್ದೀರಾ.
Artificial leg replacement ಆಗ್ಬೇಕು ಅದಕ್ಕೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. Paying interest. Condition is specific melody, not be able to move.
Know that you file an application for additional documents also, we'll see. After seeing that how much it can be enhanced, then only you can deny it. After condoning the delay, you will produce number of documents and making this thing. You produce everything along with that application. And also you file better affidavit to explain when you have given that advocate.
Condition is specific method. It may be condoned method.
No. 8 years, 10 years.
I understood method. Normally will not entertain.
We don't know what has happened in between that, Mr.
Method.
You specifically state when you have given to that advocate, you have not taken any action against that advocate. 10 years al anta hot accident agirbodu.
Illa, that is
Then
clear.
you produce medical records also, we'll see is it related to this, then file in a better affidavit, then we'll consider. Yes. Is this matter after 2 weeks? 44. Number 44. First time now. Yeah. Insurance company. Yes, also. Number 45, Balraj AC for appellant.
Well, I pay for the applying for that. Appeal my lord. It will not. 10%.
ಇನ್ಮೇಲೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ? 10% ಮಾಡಿದ್ದಾರೆ. ಅದರ್ 90% is on whom? Sorry, 10% on you. Where is that?
Page number.
Component number 3.
Page number.
KSRTC is liable to pay 10% of compensation amount out of the total compensation. Yes. Third, issue notice. Day of statement and award dated 3rd November 2022, passed by MEACT Bangalore in MEC 202 of 2019, subject to condition. Appellant has to deposit 10% of the compensation amount with interest before this court within 4 weeks.
New India Insurance.
New India Insurance ಯಾರಿದ್ದೀರಾ? Reddy, you are there. You are there, Patil. Yes. Respondent. Number 2 is served unrepresented. In the Munche, there is a delay of 143 days in filing an appeal. IA 1 of 2023 is filed for condemnation of delay. Respondent served unrepresented. There is that, by extension for time for deposit.
Bill by owner of the vehicle ownership.
Bill owner of the vehicle.
Vehicle ownership. Yes. Honorable court my lordship stay the interim judgment and award my lordship up to 50%.
50% deposit ಮಾಡಿಲ್ವಾ?
To the financial crisis my lordship.
But how can condone delay, Mr.? You have to comply first.
Lordship. For extended it.
Within period of 8 weeks from today ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾವಾಗ ಹೇಳಿದ್ದಾರೆ? 23/9/2023. ಈಗ ಆಲ್ರೆಡಿ ಆಗೋಯ್ತಲ್ಲ 4 weeks. Yes, Mr. Where is your application? IA 3 of 2023 is filed for extension of time for depositing that amount as per the directions of this court dated 23/9/2023. There is that affidavit for the reason stated in the accompanying affidavit. IA 3 of 2023 is allowed Further period of 4 weeks is granted from today to deposit 50% of the award amount with interest as per that order dated 23/9/2023. Yes. The respondent number 2 served unrepresented. Party is directed to take notice.
Kindly connect with MFA number 8317 of 2023.
Yar Bado.
By appellant Melas in another release.
Yes. All this matter along with the zones. Yes, Mr. Vikas.
Taking the aspect of quantum.
Hmm.
It is 50% ಮಾಡಿದ್ದಾರೆ.
Email 15 now.
Quantum ಅಲ್ಲಿ is a bachelor will not take one third was deducted.
Why? There are who are the claimants, other claimants? Ante taina? Yes. Or issue notice. Day of judgment and award dated 21st March 2023, passed by MEACT Bangalore in MEC 22/71 of 2021, subject to condition. Appellant has to deposit 50% of the award amount with interest before this court within 4 weeks.
Appellant.
Notice. Notice.
Village Krishna for appellant, Ken Mahabaleshwara Rao.
Kindly pass over the matter.
Pass over.
For appellant. Number 50,
Yes, Vijay Kumar. Pass over.
number 51.
The appellant. AMA not plus
Claimants appeal.
climate appeal.
IA 1 of 2023 is dismissed as not plus issue notice.
Take out the notice.
Yes.
Number 52, Ashok and Patil.
Quantum only. The tribunal has taken one of the income as 20,000. The injured is a agriculturist. There is no much proof of income. However, the tribunal has taken the income at 20,000 rupees.
What is the finding of the tribunal reasoning?
But reasoning is nothing not
Which paragraph?
and the later period is awarded for 12 months. Kindly see not the in page 29.
Which paragraph regarding
Yes,
income?
in page 29, Lord.
29. Yes.
PWN has alleged that the accident injury has rendered him permanently disabled. In this regard, PWN has asserted in his examination in chief that in the accident he has sustained grievous injury as per exhibit P6 and discharge summary. He was ill and healthy, and prior to the accident, he was aged over 28 years. When date of the accident, he was doing agriculture work and earning rupees 10,000 per annum, and was maintaining his family due to fracture injuries to his limb. He suffered so and so and so. He has lost his so and so and so. Based on this, not the tribunal has taken.
ಜಾಸ್ತಿ ಕೇಳಿದ್ರೆ ಕಡಿಮೆ ಒಂದು
Yes,
ಕೊಡ್ತಾರೆ.
yes.
1 ಲಕ್ಷ ರೂಪಾಯಿ ಕೇಳಿದ್ರೆ 10,000 ಕೊಡೋಣ.
20,000 is taken, not.
Where is that 20,000 ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? Page 36, para 31. The loss of future income has to be decided by taking into consideration the age, occupation, and monthly income of the petitioner, as discussed above. Since he's claimed 10 lakhs, therefore
Yes.
they are granting. 20.
Therefore, not 20,000 is taken.
Yes. Heard. Issue notice. Delay idea. Yes. Stay of judgment and award dated 13/1/2023 passed by MEACT Mysore in MEC 1201 of 2018, subject to condition. Appellant has to deposit entire compensation amount with interest before this court within 4 weeks. Notice to R2 and R3 is dispensed. Issue emergent notice to R1.
Pradeep for appellant.
Yes, Pradeep.
Something challenging quantum.
Quantum. Why?
As per their produced exhibit P18 DL the age about 34 years, but court has been considered 30 years. Multiplier applicable is 6
ಏನಿದೆ ಏಜ್ ಪ್ರೂಫಿಗೆ?
DL they have exhibit P18.
ಎಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಕನ್ಸಿಡರೇಷನ್ ಎಲ್ಲಿದೆ?
Criminal considered age about 30 years.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್? ಇದೆ ಕಮ್ ಟು ದಟ್ 30 years. Paragraph. Proper multiplier 17 ಏನಕ್ಕೆ? What is his age?
Age about 34 years as per exhibit P18 DL
ಅಲ್ಲ 17 ಅಂತ ಹೆಂಗ್ ಬಂದ್ರು ಅವ್ರು ಅಂತ? ಈ somewhere has mentioned his age. ಎಲ್ಲಿದೆ DL?
exhibit P18 P18
18 45. According to the DL, what is his age?
34 years as per DL.
34 years. ಯಾವಾಗ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ?
Date of accident 28/2/2021.
ಅವರೇ ಇಲ್ಲಿ 45 years ಅಂತ ಹಾಕಿದಾರಲ್ಲ, ಇಂಜುರಿ ಕೇಸ್ ತಾನೆ?
Injury case.
He himself has in the claim petition 45. Yes. But issue notice. Stay back.
3 minutes.
Day of judgment and award dated 2nd May 2023, passed by MEACT Chamarajanagar in MEC 247 of 2021, subject to deposit entire compensation amount with interest before this court within 4 weeks. Filed for dispensation of notice to R2. Notice to R2 is dispensed. Emergent notice to R1.
Veerabhadra Swamy HP.
Yes, notice.
55 Somashekhar KX for appellant AN Gangadraya.
Yes.
That is a suit for partition filed. That application was not to alien management filed.
All respondents served. Notice has to go for delay.
Now explain that after the rejection of my order 1 and 2, that the appellant filed MA before before the district judge. It came to be rejected on post 2023.
Why?
Because of the jurisdiction. That was jurisdiction law really. They rejected after 1 year. But thereafter he was a chronic heart patient. He was
You are a plaintiff or a defendant?
I am the plaintiff.
Plaintiff.
Earlier, the temporary injunction was granted. Initially, after filing a suit, the injunction was granted.
What is the suit for?
Suit for partition. We are
Partition.
seeking only not to alienate the suitable property.
Who are the plain defendants?
They're all family members, all joint family members.
Why the tribunal has the
Except
trial
one,
court
my lord.
rejected your application?
Application rejected, my lord, is that you have not explained, you have not produced the document to show that all these properties are joint family properties or ancestral property. That is only the reason. This is not the stage, my lord, to decide whether the ancestral property or joint property. Only at the time of trial, my lord, you can produce all the documents.
Where is that IA filed before the trial court for injunction?
I have learned page number. Page number, my lord.
Make a submission, please.
It is.
Yes, yes.
But it's a suit for partition filed by the petitioner hearing. There was nothing to be partitioned. The partition among their fathers was entered on 1956. Subsequently, based on that partition deed, mutations were effected by virtue of RRT proceeding in 1771. So by virtue of that RRT proceeding, all the four families were got their property, respective property, including this petitioner. They even acted upon that partition deed, and he sold 3 scheduled properties of by virtue of the earlier partition. And again, after disposing of all their property, they tried to file this suit for partition, claiming that there needs to be, there is a proper, there was no proper partition. He admits that there was a partition. When the concluded partition was there, how can this person reopen the partition?
It is not.
You are appearing for which respondent?
Then see,
2021.
I am
After the interim vacated, after the application rejected, they have sold the property in favor of 2021.
We have not sold.
When the suit is pending.
We have not sold.
When the suit is pending. Please
We have not sold the property.
Lordship, can I produce the document, Lord? So know that.
Now that by it is his risk. If you succeed, he will lose it.
Definitely.
Whatever
If
it
it
is,
is already sold.
You last
when there is a suit pending, it's a dispendency. At least without obtaining the permission of the court, they can't sell the property.
No, if they sold the property, section 52 will come into the this. Not anyhow that now there is a delay, notice has to go. Without
Notice,
notice,
ಕೇವಲ ಹಾಕಿದವರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
others,
Others,
Others will take ransom.
some of the defendants blame ex party, not speculative, not.
ಇಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ
ಅಲ್ಲ,
ಆಗಿಲ್ಲ,
ಇಲ್ಲಿ-
ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ದಾರೆ.
ಅಲ್ಲ ಎಕ್ಸ್ ಪಾರ್ಟಿ ನೋಟಿಸ್ ಹಾಕೋಬೇಕು ಅಲ್ಲಿಗೆ. You are the contesting that part, depending.
Correct.
You are contesting. You
Last
might have
week I
given
appreciate
it also. I served a copy to you. You not forget page number 2, you will page number 24, page number 4, para number 4, page 24.
page,
After issuance of source one, notice code, some of the defendant, that is defendant 1, 2, 4, 6, 15, and 18 was placed ex party. The defendant number 9, 2, 14, and 20 appear through the respective counsel. Similarly, I have served a copy to respondent number 14 and
no,
20.
what about 9?
9, ಅಲ್ಲ ಅವರು ಈಗ
9 is no more. The LRs are on record.
What about 10, 11, 12?
It was not served at all, not at served.
Wait, mister, he has to answer.
Let notice go, I have no objection, but in a word, contesting respondent who has filed a KVA, I served a copy to him.
No, when there is a delay.
Only one week back, I served a copy to him.
No, not on him. See, when there is a delay, unless it is condoned, no interim order can be granted.
Otherwise,
You take handsome others who are the contesting, who has served before the trial court.
ನಾನು ಆಲ್ರೆಡಿ ಸಮ ಇದು ತಗೊಂಡಿದ್ದೀನಿ ಈಗ ಸಲುವಾಗಿ
Handsome stand idira.
and ಸಂಬಂಧಿಸಿಲ್ಲ ಬಟ್ ಗಿವನ್ ಬುಕ್ ಆಲ್ಸೋ ಬಟ್ ಒನ್ಲಿ ಥಿಂಗ್ ನಾಟ್ ಈಗ ಹೆಂಗೂ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ 3 ಐಟಮ್ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಐಟಮ್ 62 63 64
When there is a delay, no interim order can be granted. Without condoning the delay.
status was to be maintained.
No, without
Status quo.
condoning the delay, your appeal has not yet been registered, mister. That is what that law. Therefore, I said you take handsome. Who are that other contesting? You are appearing for whom?
I am here for the respondent number 9 LRs. Only Kalan is paid for 9C.
9C.
10C.
10C.
If he appears,
If he needs to be served.
No, you are taking notice to A and B. Or notice has to go.
ಅವ್ರಿಗೆ ಎಲ್ಲ ಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತಾರೆ
A and B notice ನಾನು take. But other 11, 12, 13 also LRs of the Shankar Reddy. That is
11, 12,
11, 12, 13
hmm,
and 14.
14.
They all the LRs of Rashekar Reddy. They are in the different places.
Now, who are that who has placed ex parte before the trial court?
Lord,
I have contested the matter.
Allah, depend number,
Wait, Mr.
depend number 1, 2,
Hmm.
4, 6, 16 and 18.
Others you have to take hand summons. Defendant number?
1, 2, 4, 6, 16 and 18.
Defendant number 1, 4,
And 1, 2, 4,
1 to 4, 6,
16
16.
and 18. Only Lord, the result will file 9 to 14 and 20.
16 and 18.
I have to serve a copy to 9 to 14 and 20. Not by learned part has appeared.
No, 9, A, B, C, I take notice. But 11, 12, 13, 14, I am not taking notice.
Yes. That you will take hand summons. Yes.
20 is already present before.
Yes. Others you take hand summons.
What
Yes.
Leonard is saying that
I let him, yes,
party.
or issue notice.
Orderly,
They are in collision with the petitioner.
Wait, mister. The caveator, A.N. Gangadhar, is undertaken to appear for R10 C, R10, R10 A,
For R10C. A and B I take.
A.N. Gangadhar undertake to appear for R10 A to C. G.R. Jagdish. ನೀವು ಹೆಂಗೆ 2021 ಕೇವಟ್ ಹಾಕಿದ್ರ ಮತ್ ನೋಟಿಸ್ ಆಗ್ತಾನೆ. ಎಸ್, G.R. Jagdish
nothing going to purchase the flat.
has
Today, it is pending.
G.R. Jagdish has filed an wakalat for 20 and 21 is accepted. In respect of other respondent, issue notice. In addition,
Copy print to the lawyer court advocate.
in addition, the appellant is permitted to take out hand summons.
So advocate
also-
appear.
Advocate appearance ಗೆ hand sorry ನೀವು ಇದು ಕೊಟ್ರೆ ಕಾಪಿ ಕೊಟ್ರೆ it is not in the service under law. If he appear is good. If he is not appear, again you have to take in.
ಕೆಳಗಡೆ appear ಆಗಿದೆ.
ಕೆಳಗಡೆ ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಇಲ್ಲೂ ಅಪಿಯರ್ ಆಗ್ಬೇಕಂತ ಕಾನೂನು ಇಲ್ಲ. ಅವ್ರ ಪಾರ್ಟಿ ಬೇಡ ಅಂದ್ರೆ you will not appear. Therefore, for a convenience we can give, but it is not in a service under law. If you want, I will permit then also. You do both. Yes. In addition, he may be permitted to take out hand summons to other respondents and also permitted to serve counsel appearing for the respondent defendant before the trial.
ಸ್ವಲ್ಪ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. ಕೈಯಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟು ಅದು
What is that correction?
ಅಪೀಲ್ ಮೆಮೋ
You have to file an application. How can you file this without allowing?
ಆಲ್ರೆಡಿ ಕರೆಕ್ಟೆಡ್ ಮಾಡಿದ್ದೀನಿ. ಸ್ವಲ್ಪ ಚೆನ್ನಾಗಿ ಕಾಣ್ತಿದೆ ಅಂತ
Amended ಹಾಕಿ ಒಂದು. Amended you file it in that office. Yes.
ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಆಯ್ತು ಒಂದು.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಎಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿರತ್ತ ಇಲ್ಲಿ?
ಹೌದು ಮಾಡಿರೋದು ಕೈಯಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಅದನ್ನ ಟೈಪ್ ಮಾಡಿ
Learned counsel for the appellant take permission to file an amended cost title. Permitted to file in that register. Yes.
ಡೇಟ್ ಬಲಾಡ್ ಸರ್ವ ಕಾಪಿ.
You serve and move that matter. Serial number? Notice. You want stay?
Yes.
Stay of order subject to deposit entire compensation amount with interest before this court within 4 weeks.
I raised a substantial question of law. The facts of grounds ಹೇಳ್ಬೇಕು ಅಂತ ಆಫೀಸ್ ಅಧ್ಯಕ್ಷ. It will be overruled by that. Connected appeal, insurance company has filed appeal.
Connected appeal is there.
Yes,
They have explained the facts. Yes. Petition of learned counsel for the appellant. Respect of office subjection 56.1 is accepted. Office subjection is overruled. Post this matter next week for admission.
Just say it could be disposed of.
Yes, next week. Post this matter next week.
Enhancement Malaysia.
Yes. What is- Yes.
Both numbers will come at the one.
In case of injury, na. First matter is which is that MEC.
Why equivalent?
MEC number
MBC number 75 man.
75,
76, 70. First man.
26 of 2018.
18 man.
Which is the paragraph?
Twenty-two Malaysia.
22.
22 minutes. 38 paragraph.
22. Yes.
2500.
Date of accident 18.
18 minutes.
ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? ಇನ್ಕಮ್ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ?
7,500. 2,500.
76 ಏನ್ರಿ? 63 ಎಲ್ಲಿ ಇದಿದೆಯಾ? ಡಿಸಬಿಲಿಟೀಸ್ ಇದೆಯಾ? ಇಲ್ವಾ? ಅದು ಗ್ಲೋಬಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ದಟ್? ಹೌ ಮಚ್ ಯು ಹ್ಯಾವ್ ಸ್ಪೆಂಟ್ ಫಾರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್?
Medical expenses correct ಆಗಿದೆ.
ಎಷ್ಟು ಕೇಳಿದ್ರಿ ನೀವು? 12,000ನಾ? Yes, where is other side? Get him, we will enhance some extent if he is there. Who is that company here? Who is that Shankar Gaud? Pass on. Or next week? ಅದರಲ್ಲೂ ಅಷ್ಟೇನಾ? ಗ್ಲೋಬಲ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ವೇರ್ ಇಸ್ ದಟ್ ಶಂಕರ್ ಗೌಡ್ ಈಸ್ ಕಮಿಂಗ್? ಯಾರು ಅವ್ರ ಕಲಿಗ್ ಬರ್ತಾ ಇದ್ರಲ್ಲ? Can dispose of enhancing some for a Sara? Yes. Which is you are dispensing? Yes. Learned counsel for the appellant has filed a memo seeking dispensation of service of notice to R2. Memo is taken on record. Notice to R2 is dispensed. None appear for the respondent. Please this matter next week.
Appellant.
Yes.
For injury for enhancement.
Yes.
Accident taken place in the year 2018 Maharaj. Income taken by the tribunal Maharaj 7,500.
Yes.
12,500 can be taken Maharaj.
ನೀವು ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? ಕ್ಲೈಮ್
15,000. 20,000 per month.
ಡಿಸಬಿಲಿಟಿ?
Disability Maharaship for the 60% to the whole body assessed by the doctor Maharaship.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್?
Page number 23, para 25 Maharaj. Total disability applicable to whole body 50%. Assessed by the CW1.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Tribunal fully taken Maharaj.
ಡಿಸಬಿಲಿಟಿ ಅಂಡ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
Pain
How
and
many
suffering,
days you are in that hospital?
7 days simulation.
What are that injury, Mr.?
Injury Maharaship. Serious in right anterior temporal annexity with terminated fracture of multiple facial bones. Head injury with facial injuries. Pain and suffering 40,000 hardship. Lower side.
I 30.
Paid up period 1 day 15,000 awarded.
Yes. So and so, learned counsel appearing for claimant has contended that at the time of the accident, he was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 7,500 per month is on lower side. Secondly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 7 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Sri Reddy Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, hence, tribunal has rightly assessed notional income of the claimant as 7,500. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant, and considering that discharge summary exhibit P10 and wound certificate exhibit P7, the compensation awarded by the tribunal for loss of immunities, pain and suffering, other incidental expenses just and reasonable. Interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties arose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 3/11/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA04JE0651. Due to that accident, claimant has suffered the following injury. The tribunal has rightly assessed whole body disabilities 50%. 50 60%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per that guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2018, notional income has to be considered as 12,500. At the time of the accident, he was aged about 30 years. The multiplier applicable to the age group, which is 17. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, claimant has suffered the opposite injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 20,000 to 30,000, pain and suffering from 40,000 to 45,000. Loss of income during the later period has to be granted for 2 months. The enhanced compensation amount carries 6% interest. Yes.
59, Buddha Prasad stating for appellant, Ravi S. Samprati.
Ready?
Yes.
Yes. Hmm. 20%.
70.
Hmm.
Considered 11,000 per month.
2019. %. Stock estate is there 40?
47%.
Whole body?
3.5%.
15. Pain and suffering go
21 days he was in the hospital.
medical expenses. 21 days, huh? 41. Medical expenses, conveyances.
Lots of income being made up.
5 months ಕೊಟ್ಟಿದ್ದಾರಾ? Interest? 6 months. Yes, Mr. Ravi.
Income 14%.
Disability?
Disability 16%. Third amount is 47.
Yes.
16% will be.
Sir. So learned counsel appearing for insurance company has Climax has contended that due to that accident, Climax has suffered grievous injury. He has undergone surgery. He has suffered head injury. He has examined the doctor. Doctor has assessed disability to 47% to particular limb and 23.5% to that whole body. Tribunal has assessed whole body disabilities 15% is on lower side. Further contended that due to that accident, Claimant has suffered grievous injury. He was inpatient for a period of 51 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, the Ravi learned counsel appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 23.5% to whole body, tribunal considering that injury suffered by the claimant, considering that medical records has rightly assessed whole body disabilities 15%. Even though claimant has claimed that he was earning 27,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 11,000 per month. Lastly, he has contended that considering that the evidence of doctor and injury suffered by the claimant and considering that medical records, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 6/4/2019 due to rash and negligent driving of rider of motorcycle bearing registration number KA01 JC 7298. Due to that accident, the claimant has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 47% disability to particular limb, 23.5% to the whole body. Considering that evidence of doctor and injury suffered by the claimant, considering the discharge summary exhibit P8 to 10 and wound certificate exhibit P9, I am of the opinion that all body disabilities can be assessed 16%. Even though claimant has claimed that he was earning 27,000 per month, he has not produced any document to establish the same. In other circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2019, notional income has to be considered as 14,000. At the time of the accident, what is his age? 45 years. The multiplier applicable to that age group which is 14. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 51 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 40,000 to 60,000. Loss of immunities from 25,000 to 40,000. Loss of income during the later period has to be granted for 5 months. Convenience, food and nourishment, attendance charges has to be enhanced from 20,000 to 30,000. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit 80% of the compensation amount with interest within 6 weeks from date of receipt.
For appellant, Gurdev Prasad KT.
Yes, connected appeal. The appeal may be called along with that so and so. Yes. This appeal may be called along with that. ಬಂದಿದ್ಯಾ? You are appearing for Narsim Raju. Yes. Next week. Why? Insurance policy ilva? Yes, Mr. Next week you can better settle. If it is enhanced, then he cannot. Yes. First week of January 2024. Yes. Ado connected, huh? Yes, to serial number? 14. Yes. Call this matter along with that so and so on first week of January 2020. Yes.
For appellant, Manjula and Tejasvi.
Yes. Ready. Who are that married daughter? But 50%. What they said. But another judgment says 50%.
National Insurance Company versus Dhirendra.
ಅದನ್ನ follow ಮಾಡೆ.
We can follow the Supreme Court judgment. This court judgment is binding.
Where is that judgment? Now, when do you want? Yes. Leave this matter next week at the request of counsel for the respondent. Yes. In case of injury or death. Yes. Where is that discussion? CW2. ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟ್ರು? It measures shows the disabilities of the life provided with 4% and whole body physical disability. 4% ಅದು. ಹಾ 41 ಅದು 4 ಅಂತ ಇದೆಯಲ್ಲ 41. ಎಸ್ ಮಿಸ್ಟರ್ 41 13 ಹೇಳಿದ್ರು.
One type compound fracture, one side leg and other multiple 10%.
4% doctor said is correct. 41% ಇದೆ. Limb is 41. Whole body is 13. Doctor said. Normally 36. Yes, 13% is right. Yes. Tribunal has taken 10%. Income ಎಷ್ಟಿದೆ? ಅಲ್ಲ ನಿಮ್ದು ಎಷ್ಟು ಇನ್ಕಮ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? 35,000. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 9. ಯಾವಾಗಿಂದ ಆಕ್ಸಿಡೆಂಟ್? 2018. 12/5. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ? Pain and suffering. ಎಷ್ಟು ವಾಟ್ ಆರ್ ದಟ್ ಇಂಜುರೀಸ್? ಫ್ರಾಕ್ಚರಾ? Yes. Yes. Medical expenses, food, nourishment ಕೊಟ್ಟಿದ್ದಾರೆ. Income during the period of treatment. 3 months. 3 months ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. Future earning. Amenities. Interest 9% ಕೊಟ್ಟಿದ್ದಾರಾ? Yes, that's all. We'll consider.
Maybe retained only income may be.
Yes. Also, Learned Council appearing for claimant has contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 10 days. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 41% disability to particular limb and 13% to whole body. Tribunal has assessed whole body disabilities. 10% is on lawyer side. Secondly, he has contended that at the time of the accident, claimant was earning 25,000 per month. Tribunal has assessed notional income of the claimant as 9,000 per month is on lawyer side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lawyer side. Hence is sought for enhancement of compensation. Contra, Sri Sanmati, Learned Council appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 13% whole body disability, considering his age, considering the age of the claimant and his avocation and the medical records produced by the claimant, the tribunal has rightly assessed whole body disabilities is 10%. Secondly, he has contended that even though claimant has claimed that he was earning 25,000 per month, He has not produced any document to establish the same. Therefore, tribunal has rightly assessed whole body disabilities 9,000 per month. He further contended that considering that the evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal, and interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 8/5/2018 due to rash and negligent driving of driver of the car bearing registration number KA27B8208. Due to that accident, claimant has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 41% disability to right lower limb, 13% to whole body. Considering that evidence of Dr. Nagaraj BN PW2 and considering that wound certificate exhibit P3 and discharge summary exhibit P5, I am of the opinion that whole body disabilities has to be assessed 13%. Even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed. Considering that chart prepared by Legal Service Authority for the accident occurring 2018, notional income has to be considered as 12,500. At the time of the accident, he was aged about 22 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, due to the accident, claimant has suffered the following injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has suffered the disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses, considering that the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 40,000. Loss of immunities from 35,000 to 45,000. Loss of income during the later period has to be granted for 3 months. Compensation awarded by the tribunal, in the other hand, are just and reasonable. Enhanced compensation amount carries 6% interest. Yes, that will be in space.
On MFA number 10,055 this was on 19/4/2018. Again, the same cause of action able to get by the.
Yes, Mr.
That initially we have filed the MFA number 10/355 of 18 challenging the EX. Point number 2 has filed miscellaneous petition. After contesting the petition, tribunal has passed the judgment on.
No, earlier ex parte has been passed. What is that compensation?
Judgment,
Wait.
challenged by this appeal.
What is that award passed in that earlier judgment?
Clear judgment, 2,02,000.
2 lakhs 2,000. What is the date?
9/10/2018.
9/10/2018.
18.
Yes. Then he has that we have challenged for enhancement. Then he has filed a miscellaneous. That earlier 9/10/2018 has been recalled. Recalled. Yes. Then what has happened? MFA has withdrawn. What? File an application for recalling, mister. You recall it and get it disposed in view of that subsequent.
Award dated.
Yes, mister. That has been recalled, dismissed, but that judgment and degree itself has been recalled. Then no consequence. Yes, here he has challenged. You yourself has filed in a miscellaneous. Now it has been enhanced 2 lakhs. By filing in a miscellaneous, then you have suffered more compensation. Yes. Now that is it in case of injury or injury? Yes. You have not filed any appeal. Yes. What is that monthly income? 20,000 you have claimed.
20,000.
What is that tribunal
9,000.
date of accident?
3/1/2018.
18. Yes.
Days inpatient leave.
2 days.
Yes, fine.
Doctor examine ಮಾಡಿದ್ದೀರಾ?
Not a treated doctor.
Yes, treated doctor by oversight judgment ಅಲ್ಲಿ not treated doctor ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ.
ಆಯ್ತು, ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಿಸಬಿಲಿಟಿ?
15% whole body.
45%?
Tribunal taken 10%.
10%. Yes.
Income.
Pain and suffering
20,000.
income during that later period.
Later period and attendance charges ಕೊಟ್ಟಿಗೆ award ಮಾಡಿ 50,000 ಕೊಟ್ಟು.
1 month ಅಂತ ಅಂದ್ರೆ 2018.
3 months.
ಎಷ್ಟು ದಿನ ಇದ್ದೀರಾ? ಇವಾಗ ದೇರ್ ಇನ್ ಒಂದು 5 days. 2 days you are there, mister.
Yes,
But
Yes.
taking rest in
2018. 18 ಗೆ 12,500, 15,000. ಇನ್ನೊಂದು 3,000 ಜಾಸ್ತಿ ಬಂದಿದೆ. ಎಸ್. ಟುವರ್ಡ್ಸ್ ಲಾಸ್ ಆಫ್ ಇಮ್ಯುನಿಟಿ ಸ್ವಲ್ಪ. ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರಪ್ಪ?
6% ಫ್ಯೂಚರ್ ಮೆಡಿಕೇಶನ್ award ಮಾಡಿ.
ಎಷ್ಟಿದೆ?
ಮಾಡಿಲ್ಲ.
ಹ್ಯಾವ್ ಯು ಕ್ಲೈಮ್? ಡಾಕ್ಟರ್ ಹೇಳಿದಾರಾ? ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್?
He's not a treated doctor.
He is the treated doctor. Cross examination.
ಆಯ್ತು, ವೇರ್ ಇಸ್ ದಟ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್?
30,000 ಹೇಳಿದ್ದಾರೆ.
Tribunal has not considered. Why? There is no discussion. ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. ಏನು you have undergone any surgery, mister?
All of implant.
Yes. That's all.
Interest taken 2018 to 16/12/2021.
Hmm.
Not carry interest. Again, dismiss the 19/12/2018.
ಯಾವುದು?
MFA.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. ನೀವು ಯು ಹ್ಯಾವ್ ನಾಟ್ ಅಪಿಯರ್ಡ್.
ಅವರು ಚಾಲೆಂಜ್ ಮಾಡೋದು ಮಿಸ್.
ಆಯ್ತಪ್ಪ. By restoring, by filing in a miscellaneous application, you have made it all this mess. Otherwise, he has to claim only enhancement on 2 lakhs. Yes. That so and so learned counsel appearing for the claimant has contended that due to that accident, he has suffered grievous injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered permanent partial physical disability to right leg at 45%, whole body disability is 15%. Tribunal has assessed whole body disability is 10% is on lower side. Secondly, he has contended that at the time of the accident, claimant was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 2 days. He has suffered lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Further contended that due to that accidental injury, he has undergone surgery. Doctor has deposed that he required 30,000 rupees for removal of the implant. Tribunal has not awarded any compensation for future medical expenses. Hence, he sought for enhancement of compensation. For contra, see, counsel appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 15% whole body disabilities, considering that age and avocation of the claimant and considering that medical records, tribunal has rightly assessed whole body disabilities 10%. He further contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, tribunal has justified in assessing notional income of the claimant as 9,000 per month. Further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable, hence sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 3/1/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA32 EK 9423. Due to that accident, claimant has suffered the following injury. Doctor C.V. Kumar has been examined as PW2. In his evidence, he has deposed that claimant has suffered 45% disability to right leg and to whole body. Considering that evidence of doctor and injury suffered by the claimant, and considering that medical records, I am of the opinion that whole body disability has to be assessed 15%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, notional income has to be considered as 12,500. At the time of the accident, he was aged about 19 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, claimant has suffered the aforesaid injury. was inpatient for a period of 2 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I'm inclined to enhance the compensation for pain and suffering from 20,000 to 30,000. Loss of immunities from 20,000 to 30,000. Loss of income during the period of treatment, rest and attendance charges has to be enhanced from 15,000 to 18,000. Due to that accident, claimant has suffered the aforesaid injury. He has undergone 2 surgeries. Doctor has deposed that the claimant required 30,000 rupees for removal of implants. Considering that injury suffered by the claimant and medical records, I am of the opinion that the claimant requires 30,000, but he has not produced any estimation. Therefore, 15,000 has been awarded for future medical expenses. It will not carry any interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as. Yes. Let us say yes. Yes. 70. 74, you are appearing for appellant. At the request of counsel for 74, leave will yes, you are there. Yes. Please this matter. First week of January 2024. Yes. Yes. 34. 34 in second list. 34 in 2 weeks. Yes.
Court officer. Court officer. Serial number 76. Court officer. Court officer. Court officer. Serial number 76. Court officer. Court officer. Serial number 76.
ಹಲೋ ಹೇಳಿ ಮೇಡಮ್.
Serial number 76, sir, please.
ಇದೆ ಇನ್ನ
Okay,
ರೀಚ್
sir.
ಆಗಿದೆ.
Okay, thank you, sir.
ಸರ್ ಇದನ್ನ ತಗೊಳ್ಳೋದ?
ಗುರುವಾರ ಆಗಲ್ಲ. ಗುರುವಾರ
ಯಾವ್ದಪ್ಪ ಕನೆಕ್ಟೆಡ್ ಫೈಲ್ಗಳಿಗೆ
ಅಲ್ಲೇ ಇಟ್ಬಿಡಿ.
ಎಲ್ಲ
ಒಂದು ಬ್ಯಾಟ್ ಮೇಲೆ ಇಟ್ಟು. ಸರಿ ಎಳ್ಬಿಡೋಣ ಇದು. ಎರಡು ಒಂದು. ಏನ್ ಮಾಡಿ? ಇದೆರಡು ಒಂದೇ ಮಾಡುದು. ಇದು ಮೇನು. ಎರಡು ಫೈನಲ್. ಆಯ್ತು ಸರ್. ಎರಡು ಮೂರು.
ತೆಗೆದ್ಬಿಡಿ ಹೇಳಿ. ಇದು ತೆಗೆದ್ಬಿಡಿ ಎಲ್ಲ ಈ ಕಡೆ ಬಂದ್ಬಿಟ್ಟೆ ಕಷ್ಟ.
ಇನ್ನು ಆಚೆ ಹೋಗುತ್ತೆ ಸರ್. ಇನ್ನೊಂದು ಇಲ್ಲ ಇದು. ಸರ್ ಇನ್ನೊಂದೆಲ್ಲ ಇತ್ತು ಸರ್. ಇನ್ನೊಂದಿದೆ.
ಬಾಗಿಲು ತಂದ್ಬಿಡಿ.
ಅದು ಸುಮ್ಮನೆ ಸವಸ ಆಗುತ್ತೆ. ಪೇಪರ್ ಕೊಡಿ ಸರ್. ರೌಂಡ್ ಮಾಡಿ. ವೇಸ್ಟ್ ಪೇಪರ್ ಒಳ್ಳೆ ನಂದಲ್ಲಿ ಹೋಗಲ್ಲ ಅದು. ಇಲ್ಲೇ ಇದೆ. ಅದು ನೆನ್ಸ್ಕೊಂಡ್ಬಿಡಿ.
ಸರ್ ಫ್ಯಾನ್ ಆಫ್ ಮಾಡ್ಬಿಡಿ. ಹೊರಡುವಾಗ ಟೈಮಲ್ಲಿ ಎಲ್ಲ ಹೌದು.
ಮತ್ತೆ ಲಾಸ್ಟ್ ಕೂತ್ಕೊಂತ ಅದಕ್ಕೆ ಫೈನಲ್ ಆಫ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ
We will call passover once, list complete.
Number 65, list number 2, serial number 65, Guru Prasad BR for appellant, Group Sitaram Rao.
Yes.
I appear for the respondent, Manoj.
Yes. Yes.
Enhancement 2017.
17, huh?
17.
Yes.
Was working as the apprentice, was working in a footwear shop and earning 15,000.
Yes.
10,000 has been taken. To ask for a charge 7,000. But the doctor stated 19% visible to the left lower leg. 7% to whole body has been taken.
Shooting.
But it was an inspection for a period of 5 days. There is some on the
Yes. Immunities. 3 months. Medical bills, attendance charges. Yes. Interest of
6%.
6%. Yes, Mr. Anu, that's all.
That's all.
Yes. So learned counsel appearing for. Senate has contended that at the time of the accident, he was earning 15,000 per month. As assessed notional income of the claimant as 10,000 per month is on lower side. Further contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities Other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri Anup, learned counsel appearing for insurance company, has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 10,000 per month. Secondly, he has contended that considering that evidence of doctor and injuries suffered by the claimant and considering that medical records, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses are just and reasonable, hence sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 19/5/2017 due to rash and negligent driving of rider of motorcycle bearing registration number AA 19 ER 5447. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. The circumstances, notional income must be assessed, considering that guidelines issued by Karnataka Legal Service Authority for the accident occurred in 2017, 11,000 has to be considered. Tribunal has rightly assessed whole body disabilities 17%. 7%. As on the date of the accident, he was aged about 26 years. Multiplier applicable to that age group is 17. Accordingly, loss of future earning has been reassessed as follows.
7%, 1,57,080.
Due to that accident, claimant has suffered the above said injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 40,000. Loss of immunities from 25,000 to 40,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by tribunal modified.
Serial number 66, VP Siddharamaya for appellant.
Claimant appeal for enhancement.
Yes. Case of injury. What is the date of the accident?
Date of accident is 14/12/2020.
2020. Yes. On what ground you are challenging, Mr.?
Future loss of earning. Attendance charges in there.
Income disability ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Not disability. Disability consider ಮಾಡಿಲ್ಲ madam.
Why? Then grievous injury. Yes, Mr. Not ready. Yes. At the request of counsel for the appellant, leaves this matter first week of January 2024.
Serial number 67, Rangaram V for appellant. Connected matter. Kalpana.
Yes.
Government advocate.
Part 21.
You are appearing for respondent 21 KVTA.
In the MFA.
ಏನು ಎರಡಿದವಾ?
Now there are two of them. One, what happened was there's an RPA pending where some of the landowners claim a right in property. There is another
that was pertaining, relating to lot of suit filed for injunction.
Hmm.
So that's the RFA. Then Lord, we filed a suit against them and an injunction was granted. That was challenged before this honorable court, then the MFA, which is the MFA with my lord, which my learned friend appears in as well. There, Lord, the order was set aside. Then the matter went to the Supreme Court. Supreme Court would not set aside the order of this court and sent the matter back, directed parties to maintain status quo. And said that the RFA and this must be heard together. That is how not the RFA is before my lord.
Now that matter has to be heard finally.
Yes.
RFA is now admitted. RFA, my lord, is filed by the plaintiffs. It is a suit for injunction. And when the RFA is pending, the respondent, my lord, who are the defendants in the injunction suit, who are respondents in the RFA, files a different suit for injunction, one more, that is called second action.
Yes.
And the trial court, my lord, granted an order of injunction. We challenged it in the MFA. But this court has passed a very considered order on merits of the matter. And on one short ground about the suppression of fact, the Supreme Court found that the suppression of fact is not there. So therefore, the matter has been remitted back to this honorable court. Both MFA and RFA should be clubbed together.
Where is RFA? Oh, it's there.
RFA is also there.
And now the RFA is admitted. So far as the MFA is concerned, the short question would be, when they are the respondents in the defendant, and when an application for injunction is pending in the RFA, can they entitled to file a suit for injunction, invoking the cause of action of 2014. Suit was filed in 2020. This court on Miller framed three questions based on 1931 Privy Council, followed by Canara Bank, my Lord Justice Rohinton Nariman Jain. When there is a subject matter is one and the same, cause of action is the same, relief is the same, second action cannot be instituted by the same party who are to the litigation. A very well considered order on merits has been. But on a short ground about the suppression of fact, 1, 2, 3, 4 grounds have been considered by this honorable court in MFA, and it is ordered to be reported. At length it was argued. On first ground of suppression of fact, the apex court found that we don't find that there is a suppression of fact. Therefore, the matter has been remitted back in the RFA with the direction that the status quo. Now, in the MFA. Now, my lord, I will just take only 2, 3 sentences. I am the absolute owner of the property. Purchased, my lord, on 30th of June 1958. Unfortunately, my father, my lord, who deceased, has mortgaged this original title deed with somebody. At that point of time, 2,000 rupees. Now the man has demanded 3 crore 4 crore. We could not redeem it. We could able to redeem it only, my lord, 2 weeks back when the matter is appeared in the Supreme Court. We filed
now we will hear all that RFA, MFS and all together. We'll fix
yes,
it after
and an application for original sale deed is placed on record. My learned friend representing the builder who had an agreement with the vendors of the appellant before your lordship, and they sold it. Now, after an agreement JD with the builder, they started claiming the sale deed itself is a forged one. If it is a registered document, within 3 years, they could have started for declaration under the Article 58 of the Limitation Act. That has not been done. Criminal proceedings have been launched against me. This court found after 65 years, you can't proceed with the criminal proceeding. That has been filed. In that case, they admitted that we came to be in possession of the illegal sale deed. Yes. These are all the admitted facts.
Not
the trial court.
Not admitted.
No.
Not admitted facts. Facts and admitted and Or
I am
get
not, making notes of any
No, no.
admission made by the advocates.
If I
Only
tell
I am
on
hearing
facts.
because I am not hearing that
No,
matter.
no, if
you
I
say
tell
that-
on facts,
Allow this appeal also. I am not recording anything.
no, no.
Just
If
a-
if I made a submission on fact, I am very careful in my career, not like others.
No, I will fix the date. Now, today I can't hear that.
Yes.
Not your lordship, I have it on 20th. We'll put it.
No, 20th is that last working day.
ಇಲ್ಲ ಇಲ್ಲ one hour ಅಲ್ಲಿ ಮುಗಿಸ್ಬಿಡಿ.
Now we'll have it on 3rd or 4th January. Any date which is convenient to both of them.
Fourth.
4th. Yes.
Blood, every time the matter goes to different was one judge disabled, another judge disabled. It went to the other judge. These are all things going on.
Now,
Yes,
why is
but
that
your lordship
disabled? Is there any judge as disabled?
Lordship is
Krishna Kumar
disabled,
Singh.
not because he was appearing for us earlier.
Then, so I don't think I am disabled because I have not appeared any matter in Bangalore civil court. That's why-
Allah, that we know.
No, that after vacation.
Blood, your lordship, I have it on 20th. If there is a time of one hour, we'll try to make a
Yes,
beginning.
20th.
Otherwise,
Right.
we'll have it on summer.
Yes, leave this matter on 20th.
Yes.
Yes.
If the time is there, Milord, to a
Yes,
budget.
because by seeing that, I don't think it will complete 1 hour. I thought that it requires, that is last week of that vacation. So many matters are moving.
Otherwise,
All that
we have to
injunction-
speed it up. Vacation.
ಇಲ್ಲ, 20 ಬರಲ್ಲ.
Allah,
ನೋಡ.
time.
Let us see that on 20th. Yes.
Oh, I have no difficulty. I am here.
Yes, leave this matter on 20th.
Number 68, Patri Vishal for appellant, corrected matter, Prashant
No, appear for the appellant Bharat. Milord, I do one thing, Milord. I'll start. By the time I complete, my learned friend can join. No difficulty. Milord, this is not, Milord, there is a difficulty for us, Milord, because we are coming to the nearing of the vacation. I know the pressure of the board. We can't. So let us, Milord, let me have the opportunity of starting the case. I will place the facts. Then my learned friend can join, because I'm just going to place the facts. Milord, I don't understand, Milord. This is not fair on my job. No, it is adjournment by 1 hour. I have no. Milord,
You are there, you make
yeah,
a note.
notes.
Senior counsel, you make a note. Yes, yes.
Notes.
Then you can say that whatever is this thing, you can argue for that. He is not, no, when that one counsel is arguing, you cannot be allowed to argue when that others is arguing. You have to take a note only. You do that and assist your senior. Yes.
Milord, there are 3 matters now, Milord, posted before your lordships, pursuant to your lordship's directions last time. The Honorable Chief Justice Milord has now directed that all the 3 matters should be posted before your lordships.
No,
The 3
because
matters
that,
are, Milord, MFA number 5348 of 2023, which arises out of an order dated 15th of July 2023 on IAS 2 and 3.
no, this is the matter that day you have argued.
Yes, sir. Yes.
Why is again come back to me?
But because the 2 writ petitions have been clubbed along with the MFA. That is why it is before your lordship, by special order.
Now that it has to go before that writ petition bench.
No, Milord, there is an order by the Honorable Chief Justice.
Chief Justice.
Yes, yes, yes.
Yes, along with that MFA. Yes.
Yes.
Now you have to argue fresh.
Yes. I know.
Refresh my memory.
I understand. Of course.
Yes.
I understand.
Yes.
Milord, there are 3 matters before your lordships, Milord. MFA number 5348 of 2023.
Yes.
That arises out of an order dated 15th of July 2023
Yes.
on IAS 2 and IA number 3. By which, Milord, injunction has been granted against my client
Yes.
from alienating the property.
Yes.
Then, Milord, there
Oh,
is,
you are the plaintiff or a defendant?
I appear, Milord, for the defendant.
Only 2 persons, huh?
Yes, sir.
Yes.
Now, then, Milord, there is in the same suit,
Yes. Suit for?
Milord, this was a suit for specific performance of an agreement dated 28th of March 2017.
Yes.
It is a suit, my lord, a peculiar suit that has been filed by the vendor.
Yes.
Normally, my lord, a suit for specific performance, as your lordships are aware, is filed with the purchaser, saying that the vendor is backing off.
Yes.
Here is a suit filed by the vendor, who says that the purchaser has to pay me X amount of money. I'll come to the details later. Under the agreement dated 28/3/2017, please ask him to pay me that money. This is their case. Then, my lord, in that suit, the plaintiff, my lord, filed an application seeking for amendment of the plaintiff.
Yes.
That, my lord, amendment is IA number 1 under Order 6, Rule 17.
Yes.
That amendment has been granted.
Yes.
As against which, my lord, we have filed WP number 17006 of 2023.
Yes.
68.1, my lord, in the
68.1.
Yes.
WP.
This is the writ petition challenging an order passed under Order 6, Rule 17,
Yes.
granting the amendment of the plaint as prayed for by the plaintiff.
Yes.
In that very suit, my lord,
Yes.
we as defendants
Yes.
filed an application under Section 52 of the Transfer of Property Act,
Yes.
seeking that the transactions that we may enter into with third party should be relieved of the burden of Section 52.
Yes.
Which your lordship are aware, my lord, is permissible. That was IA number 3.
This amendment is IA number?
IA number 1.
Yes. IA number 3.
IA number 3 was an application filed by us as defendant in the suit
Yes.
under Section 52 of the Transfer of Property Act. That application, my lord, IA number 3, came to be dismissed.
Yes.
As against that,
Yes.
we have filed WP number 17077 of 2023,
17.
which is 68.2.
17077. Yes.
That is how, my lord, there are 3 matters before your lord.
Yes.
All these arises out of OS number 621, 621,
Yes.
631 of 2021, which had a old number 5540 of 2020.
5540. Why that number?
I will tell you, lordship. I will tell you, lordship. There is a reason for that. Now, my lord, the admitted facts I will place before your lordship the consideration. And your lordship will kindly see how this order of injunction has been done. It is totally, my lord, suffers from a manifest injustice, error in law. My lord, we had produced, given your lordships, my lord, a list of dates. Sir, list of dates for the last time. Now, on 1/6/2016, my lord.
Yes.
Yes, Nagaraji, who is the plaintiff
Yes.
and who is the respondent in the MFA,
Yes.
had entered into an agreement to sell with one Darshita Asiana Private Limited. The sister concern, my lord, of the petitioner before your lordships. The total consideration, my lord, for the 52 acres of land
Yes.
was 119.60 crores.
Yes.
We had paid an advance of 2 crores 50 lakhs. Then, my lord, a further advance was paid. And then, my lord, there was a supplemental agreement that had been paid,
Yes.
that had entered into. We paid an additional advance of 12 crores, and therefore, my lord, the total advance that had been paid became 15.50 crores.
Yes.
Because, my lord, 2 crores 50 lakhs plus 1 crore, that is 3 crores 50 lakhs plus 12 crores, that becomes 12.50, 15.50 crores. And then, my lord, on various dates,
Yes.
several payments were made, and your lordship may kindly see, my lord.
No, now that you have filed an application for any interim application has been filed.
In Yes, my lord, I have asked for stay of the injunction.
Yes, you argue on that application instead of matter.
But
I
I
don't
have to,
think, huh?
I have to tell you what's basic, I will do that.
Yes.
I showed you as basic facts
Facts.
and then I'll argue that.
Yes.
Yes. Now, my lord, up to 23/3/2017,
Yes,
we have paid a total amount of 32.50 crores
yes,
out of a total sum of 119.60 crores.
32 point,
50 crores.
yes,
Your lordship gets it as of 23/3/2017.
yes,
Your lordship gets it, ma'am.
yes, 28/3/2017,
23.
23/3.
Yes.
Yes,
As on that day, we paid 32 crores 50 lakhs
yes,
out of a total consideration of 119.60 crores.
yes,
That is serial number one. First
Yes.
one.
yes,
Then, my lord, what happened was the extent of the property got reduced. It became 44 acres, 15 gundas.
earlier, what is that?
Earlier, my lord, it was 52 acres.
You have not mentioned that in that, this thing, your list of dates.
It's there, my lord. First one. First.
Yeah, first is that you have mentioned that extent of the property.
ಇದೆ. ಅದೇ 52 acres.
45 acres.
ಇಲ್ಲ, total consideration for
52 acres.
45 acres of land with representation that 6 acres of adjacent land to non-graduate also purchased. So about total consideration 50.
50.
Now we not a consideration that. Instead of 52 acres, it became only 44 acres, 15 acres.
Yes.
Now
Why it is reduced? Is there any by writing or?
And-
Yes.
agreement, these are all admitted up.
Yes.
28/3/2017.
Yes.
In supersession to previous agreement to sell, yes, Nagarani responded as a plaintiff and Satwa Infrastructure parties entered into a registered agreement to sell, under which total extent is 44 acres in gundas. Total consideration plot became 102 crores 6 lakhs 25,000 as against 119 crores 60 lakhs.
Yes.
And then some advance was paid, and the total advance paid was 33 crores and 25 lakhs.
Yes.
Because 32 crores 50 lakhs had been paid earlier, another 75 lakhs, therefore it becomes 33.2. Then there are certain additional payments that have been made, and then your lordship gets a whole list of additional payments. I am not going to detail your lordship on that.
Yes.
As up to 18th of November 2019,
Yes.
that is at the bottom a lot of page 3, we
Yes.
had paid a total sum of 56 crores.
Yes.
Now this 56 crores is out of a total consideration of 102 crores 6 lakhs 25,000.
Yes.
This was the first.
Yes.
Then, my lord, there were certain obligations that had to be fulfilled by the vendor,
Yes.
which the vendor did not do. And therefore, a fresh registered supplemental agreement was signed on 10th of January 2020.
Yes.
Now, my lord, you also may kindly see, my lord, the first agreement is 28/3/2017, and this is a supplementary agreement of 10/1/2020.
Yes.
Now, under this supplementary agreement,
Yes.
the consideration of 102 crores 6 lakhs 25,000
Yes.
was reduced to 90 lakhs 42,000.
Again,
Yes,
why?
because of the fact that the vendor had failed to discharge certain obligations. I take your lordship to the agreement.
Yes.
It is available not for your lordship consideration.
Now it comes to 90 crores.
It is a receipt document.
Yes.
Now, my lord, it became 90 crores 42 lakhs.
Yes.
And we had paid, and a further advance was paid on that day.
First is 100 crore 19 lakhs.
Yes, correct.
Yes.
First was 119 crores 60 lakhs.
Yes. Then
Next
one
was
not.
102 crores 6 lakhs 25,000.
Yes.
Now, my lord, it became 90 crores 42 lakhs. And this is a registered document.
Yes.
And even under this document, my lord, they received a further advance of 7 crores
Yes.
and a further payment of 5 crores.
Yes.
And therefore, my lord, the total advance that was paid was 68 crores. So, my lord, this is the position.
Yes.
Then, my lord, we have paid further advances. Your lordship gets all that.
Yes.
And then, my lord, a general power of attorney is also executed in our favor, pursuant to the agreement of 10/1/2020.
Yes.
General power of attorney is also executed.
When?
My lord, that general power of attorney was executed on 10/1/2020.
Then
That is
one.
at page 148 of your lordships.
Yes. 10/1/2020. Yes.
Yes, from 10/1/2020, there was a general power of attorney It is mentioned there, my lord. Yes, Nagaraji responded on the same day.
In this synopsis 10/1/2020, there is a supplement agreement to sale.
Yes, sir. And then next paragraph, my lord.
In the same day they have.
Same day, same day.
Yes.
Yes, same day.
Yes.
Yes, Nagaraji, on the same day, also executed the registered power of attorney coupled with interest in favor of Satwa, who is the plaintiff petition to your lordship in appellant,
Yes.
including right to transfer or convey by way of sale of the scheduled property.
Yes.
This was the position. And now we come, there are various further advances that have been paid.
Yes.
I am going to not trouble your lordship with the details. Kindly now turn to date 16/10/2020 over the page.
Yes.
Total advance paid was 82 crores 75 lakhs. Not in dispute.
Yes.
On as of 16th of October 2020,
Yes.
we have paid them a total sum of 82 crores 75 lakhs. In other words, my money
Yes.
is in his pocket.
Yes.
This is the position.
Yes.
Now, when this was the position, on 9th of November 2020, this litigation starts. Not the present litigation. I will tell you, lordship, what is litigation. There was a suit that was filed in OS number 5540 of 2020. Your lordship asked me what is the old number.
Yes.
This is the old number.
Yes.
5540 of 2020. On 18/11/2020, the court passed an order returning the plaintiff,
Yes.
saying no jurisdiction. Now, between these dates, my lord, there is an important event that took place.
Yes.
On 15/6/2020, on 15/6/2021,
Yes.
a sale was executed in favor of the defendant on the basis of the power of attorney. That power of attorney was there, your lordships.
Yes.
Power of, because that power of attorney specifically said, I authorize you to sell the property in your favor.
Yes.
Because they had received so much of money from us. Now, my lord, that power of attorney is dated 15/6/2021.
Now that power of attorney is executed in your favor.
Yes, sir.
Now you have sold the property.
My favor.
Yes. Oh, in your own favor.
And that power of attorney says, you please sell the property in your own favor.
Yes.
That there is a specific clause. There is no hide and seek about it. That a power of attorney specifically says that you can sell the property in your own favor. I am authorizing it.
Yes.
For having regard to the fact that such a large amount of money has been paid.
Yes.
So, my lord, we come to that. Now, my lord, as I point out your lordships, 18/11/2020, the plaint was written. I want your lordship to kindly see that order.
Yes.
If your lordships are kind enough to turn to page number 299.
Yes.
Your lordship.
Yes.
Plaintiff counsel filed an advancement application to advance the case for considering the application to be filed for return of the plaintiff. Case is advanced, taken on board. Learned counsel appearing the plaintiff has filed an application after 7 root.
Yes.
Please return the plaintiff. Contending that the suit scheduled property which is subject matter of the present suit is situated in Nalamangala. Hence, office has raised an objection. Hence, plaintiff has filed application after 7 Rule 10 CPC seeking permission to return of the plaint for pressing the same before the concerned court. Peruse IA number 2, satisfied, the plaint filed by the plaintiff is hereby ordered to be returned to the plaintiff along with necessary document produced in this case so as to enable the plaintiff to present the same and file the same before the concerned court. Office is directed to return the plaint with due endorsement to the plaintiff. Further, the court fee paid in this case is through DVD, and if it is in cash, the cash branch is directed to direct the transfer of same to the Nalmangala subdivision to register the plaint on behalf of the plaintiff. So, the plaint was returned. This order was passed, as your lordship will kindly see, on 18th of November 2020.
Yes.
They did not represent the plaintiff. Instead, my lord, very interestingly, they filed a second suit on 9/4/2021,
Yes.
which is OS number 260 of 2021.
Yes.
That is available for your lordship's consideration at page number 188.
100?
88, 188.
In which?
In the same paper book.
Paper book starts from 200, 240.
Maybe it's one volume, first volume.
Yes.
There are two volumes. There are two volumes.
Volume 2. Volume
Your Lordship may have to see volume 1.
No, appeal memo is volume 1.
Ah, yes. 1A.
Yes.
This was the suit that was filed.
Yes. This is now its suit is under.
No, there's something more, my lord. It becomes, as they say, my lord, it becomes curiouser and curiouser as we go on.
Yes.
It is a story of Alice in Wonderland. My lord. Now, they filed this suit OS number 260 of 2021.
Yes.
Now, my lord, on 15/6, as I told your lordships,
Yes.
during the pendency of this suit, OS number 260 of 2021, said it was executed in our favor.
OS 631 of 2021.
No, my lord, 260.
Okay.
631 is different. 631 is the present case.
631 you have referred. 188 is that 631.
No, my lord, 188 is 260.
No, this 188 is 631 of 2021.
No, my lord.
Sessions Civil Judge Nalamangala.
Yes, sir. That is 200 and that is OS number 260.
631 actually.
Okay. I'm sorry, I apologize.
Yes.
If you're not give us permission, I will calculate my.
No, this suit copy, original copy you are not placed, or how that number it is only office it has. Yes. Put it. Yes, 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 yes.
I'm sorry, but I apologize. Your lordships are right, but it leads to confusion. Instead of refiling that suit OS number 5540 of 2020,
Yes.
this new suit is filed in OS number 260 of 2021.
Yes.
During the pendency of this suit, OS number 260 of 2021, said it was signed in favor of the appellant on 15/6/2021.
Through that GPA.
Yes, to the GP.
Yes. Now that you have mentioned in that this thing.
Yes, my lord. Your lordship gets it on page number 7 of our list of dates on top.
Yes.
Now, my lord, when this second suit was filed,
Yes.
the court, my lord, passes an order on 25/10/2021
Yes.
rejecting the plaint.
Second suit. Yes.
Then, my lord, your lordship gets it at page 307.
Page
307. And this order, my lord, as your lordship will kindly see, was passed on 25th of October 2021. Order on IA maintainability of suit.
Yes. Yes.
Kindly turn to para number 9, my lord, at page 310.
Yes.
As discussed above, defendant has raised his objection regarding maintainability of suit by contending that the plaintiff got returned the plaint in OS number 5540 of 2020, filed in respect to the same subject matter against him, and filed entirely new plaint by lodging the plaint by withholding the plaint so returned to him by the Honorable City Civil Court. The plaintiff also admitted the filing of the above suit, return of the plaint, and refund of the court fee. He contended that there is no bar to file the fresh suit, since after return of plaint, the court has to try the suit afresh. Hence, the present suit is maintainable. Then, my lord, I'll skip the. Kindly turn to paragraph number 12, 13. My lord, the court discusses all the case law, etc., etc.
Yes.
I will not trouble your lordship with that because that is really not material. Please be kind enough to turn to paragraph number 19.
Yes.
On the strength of the judgments referred above, I opine that the suit in the present form is not maintainable and it is barred by Order 7, Rule 10. In the factual circumstances case, the plaintiff is at liberty to present the plaint which was returned to him by the Honorable City Civil Court, Bangalore. That is OS number 5540. Subject to period of limitation. Accordingly, I answer point number in the negative, and then, my lord, the suit filed by the plaintiff is not maintainable under Order 7, Rule 10. Accordingly, plaintiff is rejected.
Yes.
So, my lord, with that, this OS number 260 of 2021 came to an end.
Yes.
Therefore, even though my sale deed dated 15/6/2021 was executed during the pendency of OS number 260 of 2021, whatever problem was there is gone.
Yes.
Because the suit still was rejected.
Yes.
After rejection of this plaint,
Yes.
by the order, my lord, that was passed by the City Civil Court, by the Nelmangla Court,
Yes.
on 25th of October 2021,
Yes.
the first suit, OS number 55540,
Yes.
was represented on 28th of October 2021.
Yes.
This is the history.
Yes.
Today, my lord, therefore, my sale deed of 15/6/2021 is perfectly valid. It is not hit by any principle of law. I am the lawful owner of the property.
Yes.
It was no doubt executed during the pendency of the second suit, but the second suit got dismissed, rejected.
Yes.
And the first suit was not there because they represented it only on 28/10/2021.
Yes.
My sale deed is 15/6/2021. Therefore, there was no litigation pending.
Yes.
They can't contend that it is lispendence because of the second suit, because second suit is dismissed.
Yes.
They can't contend that it is lispendence during the pendency of the first suit because the first suit was not there. First suit came up only on 28/10/2021. And as your lordship saw, my lord, the first suit was ordered to be returned on
Now that what is the date of the second sale?
one sale.
No, that after that GPA
One sale, 15/6.
15/6.
And in my favor.
No, the date
15/6/2021, my lord.
15/6/2021.
Yes, my lord. Your lordship get the date on top of page number 7 of our list of dates.
Yes.
Page number 7 at the calculator. Mail first date, my lord. 15/6/2021. Yes, Nagaraji, represented by GPA holder, Satwa Infrastructure, execute sale deed, any scheduled property in favor of Satwa Infrastructure Private Limited under the GPA.
Yes.
Now, my lord, before I proceed further, I want to show to your lordship one particular clause, my lord, in the GPA, which is relevant for your
Second
lordship.
suit which they have filed, there is no any injunction order, anything is there?
In the second suit, no.
Nothing.
Nothing.
Yes.
Nothing was given. Now, my lord, please see the GPA, my lord. If your lordships are kind enough to turn to page 148. And the relevant clause, which I want to point out to your lordships, my lord, is at page 154.
Yes.
This is the GPA registered document executed by the plaintiff respondent in favor of the defendant appellant.
Yes.
In pursuance of the supplemental agreement dated 10/1/2020.
Is it registered GPA?
Yes.
Yes.
Registered document. Even the supplemental agreement of 10/1 is registered document.
Yes.
Now, my lord, please be kind enough to turn to clause L at page 154.
Yes.
To transfer and convey by way of sale the scheduled property or any
Portion.
or any portion
Slash shares.
shares thereof, and to sign and execute the necessary deeds of sale, conveyance with regard to scheduled property, either in favor of my attorney itself or in favor of the intending purchaser. Transfer is nominated by my attorney, and in this we have to do everything necessary for completing the sale, conveyance, transfer of the same, including execution of sale deeds, presentation of sale deeds for concerned judicial sub-registrar, and admitting execution thereof, as well as to sign and execute all forms, affidavits, application, statement, declaration, forms, returns.
to acknowledge receipt of balance payment in my favor, yes, Nagaraja, and in this regard, to sign and execute acknowledgement of receipts and do everything necessary for completing the registration of the same, including execution, presentation, and admitting execution of the acknowledgement of the receipt of the balance payment in the present jurisdiction of the registrar. So, my lord, the power of attorney, when it was executed, clearly said, I can execute a sale deed in my own favor.
Yes.
And it is pursuant to this power that the sale deed was executed.
Yes.
Now, therefore, my lord, the first point I want to place for your lordship's consideration is, as of 15/6/2021, there was no first suit, second suit was dismissed subsequently, and therefore, whatever the cloud that might have been created on the sale deed of 15/6/2021 by virtue of the doctrine of dependence does not apply, because suit is never dismissed. What else is? Therefore, my lord,
No,
my-
if it is sought for restoration of the very same suit, then it would have
it's
been.
different. Yes, your lord. He did not. He filed a new suit, and he represented the first suit only on 26/10. 28/10. After the first suit was rejected on
28/10,
28/10/2021.
Yes.
And the first suit, my lord, and the second suit was rejected
15/6/20.
on 25/10.
Yes.
And 28/10 is represented. No problem at all. Now, my lord, I want your lordship to kindly see the prayer in the suit, which is 5540, which has been renumbered, as I mentioned to your lordship's my lord, as OS number 610.
Yes.
Now, please see the prayer in that suit, my lord, if your lordships are kind enough. The plaint, my lord, is available at page 318. Let us straight away go to page 329, my lord, which is the prayer.
Yes.
To direct the defendant
Yes.
to perform its part of the contract
Yes.
as per clause 7 of the agreement of sale dated 28/3/2017.
Yes.
That is, my lord, the agreement which provides for a consideration of 102 crores 6,25,000. Ignoring
Yes. Yes.
that there was a subsequent agreement on 10/1/2020 which reduced the consideration to 90 crores.
Yes.
In any event, my lord, that's a different issue. Now, what is this prayer? Direct the defendant to perform its part of the contract as per the agreement of sale dated 28/3/2017 and pay the balance consideration of 21 crores 30,556 and to pay an amount of 4 crores 48 lakhs towards reimbursement of expenses incurred by the plaintiff in securing the change of land use as agreed to by the defendant under clause 3(4) of the agreement of sale dated 28/3/2017 and conversion of land, and in the event of failure on the part of the defendant to comply with the same, declare the power of attorney dated 10/1/2020 executed by the plaintiff in favor of the defendant, registered as document number so and so, as null and void. Therefore, my lord, the cancellation of the power of attorney is an alternate relief.
Yes.
Significantly, my lord, there is no prayer for cancellation of any agreement to sell, because they're all registered documents. Now, my lord, therefore, his case, my lord, was purely for the payment of money. According to him, the consideration should be 102 crores 6,25,000.
Yes.
He ignores the registered supplemental sale agreement of 9/1/2020, which reduced this consideration to 90,42,000. Whether the reduction is there, not there, is a matter to be decided. In any event, my lord, this is a money suit. In that money suit, he files an application seeking for amendment. He seeks, my lord,
Yes.
amendment. The amendment application, your lordship gets it at page 333. There are so many paragraphs that he wants to add, but
Yeah, right.
most importantly, I want to draw your lordship's kind attention to page 341. That is the most important aspect.
Yes.
Cancel the sale deed. He wants to add prayer 4A.
Yes.
Cancel the sale deed dated 15/6/2021, executed by the
341.
Yeah, 341 on top.
341.
Yes, the plaintiff wants to add prayer 4A.
Yes, prayer for you.
Cancel the sale deed dated 15/6/2021, executed by the defendants by declaring it as null and void and not binding on the. He retains the first prayer.
Yes.
If not, the prayer in the plaint for payment of some 26 crores is granted, he is happy.
Yes.
Then this doesn't arise.
Yes.
Now, my lord, in such a suit, injunction is granted. Look at the situation, my lord. My money of 82 crores is in his pocket. He only wants extra money. Whether he's entitled to extra money, he is not entitled to the extra money, whether his sale consideration has, which is 90 crores, 42 lakhs, 50,000, as opposed to 102 crores. These are all matters to be gone into at a trial. And ultimately, if it is found no, the consideration should be 102 crores, he will get his money. I ask myself in the situation of this, where is the question of injunction? Look at the injustice that has been caused to my client. My 82 crores is with him. His property is with him.
Yes.
He wants that property has been sold in my favor by virtue of the power of attorney.
Yes.
And his prayer for cancellation of the power of attorney is an alternate prayer, where he says, only if you don't give me the money, cancel the power of attorney. What happens to the actions taken under the power of attorney, including the execution of the sale deed in my favor on 15/6? I have today become the owner of the property.
Yes.
He is now preventing me from selling it. I have not bought it for my own use. I am a developer.
Yes.
In this situation, my lord, I said, give me permission. I don't want this. I want to sell the property to others. Of
Yes.
course, I am a developer. My sale cannot be, is not hit by lispendents. As I indicated to your lord, the sale in my favor is not hit by lispendent. Therefore, my title is clear. I now want to sell.
Now if you want to any sale that hit by the.
Yeah, that is why I made an application under 52. Exactly, my lord. I go down. That is why I said, look, why should the doctrine of lispendents
How
apply?
you want to make further.
Yes, Lord, I am a developer. Why should I not? My 82 lakhs I paid to him. He has taken my money. And his prayer is only for the payment of this 22 crores. If it is a money suit, where is the question of granting an injunction like this?
Yes.
This is the injustice that has been caused to my client, my lord. That is why we filed an application under section 52. Now, my lord, what happens is after this suit is represented, he files an application. He is wanting this prayer to be added, that is granted. We are saying no, that should not be granted because you are changing the cause of action to the suit. Your cause of action was simply specific performance of the agreement under which you said you are entitled to 26.
What has happened to that application?
It will be allowed. That is why we have filed a writ petition challenging that application, that order under order 6/17. That cannot be, that should not have been granted because by granting a prayer for amendment of the plaint to cancel the sale deed, virtually you are changing the cause of action. A suit for specific performance owned by a seller saying, give me the money, has now been converted into a suit for cancellation. Now, that is completely different. That is why that order 6/17 is also wrong, in my respectful and humble submission. Today, my lord, when the suit was filed, it was a simple suit for recovery of money.
No, suppose. Yes, he may sort, but he has to establish. Let him whether that cancellation, whether he has to prove that is there any fraud and all.
I am now saying that should not have been granted in this suit because a money suit is being converted to a suit for cancellation. Cause of action is completely different. His cause of action is under that agreement, I am entitled to an extra amount of money. Please direct them to give me that money. Agreement is not thought to be cancelled. All those agreements, not including the agreement dated 10/1/2020, under which the consideration was reduced from 102 crores to 90 crores, has not been challenged. All the agreements are invalid, are kept intact. Now,
that you can cancel when he has seek argument cancellation of the sale deed. You
Correct.
can argue that.
Yes.
Unless cancelling that earlier agreement in
Correct.
GPA, it
Correct.
cannot be.
Correct.
That can be.
I agree with it. But today, the question I ask myself and I respectfully place it for your lordship's consideration is, A suit for recovery of balance consideration under an agreement to sell which is not in challenge, can it be converted, I ask myself, to a suit for cancellation of a sale deed pursuant to a power of attorney when prayer number A says, if you don't pay this money, only then you cancel the power of attorney. Completely different causes of action, Lord. It should not have been granted. This amendment application should not have been granted. And we have taken this specific defense. And of course, my lord, the trial court, my lord, considers it in my respectful submission in a very unsatisfactory way. If your lordship is not right, my lord, I go down to what your lordship is saying. If the amendment was rightly granted, then, my lord, all these defenses I have in response to the prayer for cancellation city. The question, my lord, is at the threshold. Should this amendment have been granted or not?
Yes.
And my respectful submission, this amendment should not have been granted. And now, my lord, that this is a suit simpliciter for money. My application under 52 is it should have been granted. This is a classic instance, if I may say so, a textbook example of when the power under 52 proviso should have been used by the court, relieving me of the burden of section. But the injustice is on the face of it. I don't have to say anything more. My 82 crores 75 lakhs is with him. Crores 75 lakhs out of a total sum of rupees 90 crores 42 lakhs.
Yes.
Namely, balance is only 7 crores 67 lakhs, which also, my lord, has been adjusted. In any event, my lord, I have instructions to submit that if it is 90 crores 42 lakhs is the consideration under the sale agreement, and they have already received 82 crores 75 lakhs, I am willing to furnish a bank guarantee for the sum of rupees 7 crores 67 lakhs to this honorable, so that his money is secure. No different. Though under the sale deed, my lord, pursuant to the clauses in the agreement, I have adjusted the 7 crores 67 lakhs also.
Yes.
Doesn't matter, my lord. That's a matter to be decided. I am willing to deposit. I am willing to be a bank guarantee to this honorable court. For
Prior is that 1 lakh, 1 crore, no, 100 crore, 20.
No, my lord. 90 crores 42 lakhs is the consideration. Out of which, my lord, admittedly we have paid 82 crores 75 lakhs.
No, that in the prior, in the
that other one, my lord, is 102 crores. 102 crores 6 lakhs. Now, if it is 102 crores 6 lakhs, my lord,
yes,
it comes to, out of 102 crores, we have already paid, my lord, 82 crores.
82
the
crores.
Balance will be 20.75 crores.
Yes.
And, my lord, I will furnish, my lord, a guarantee for the entire amount.
Yes.
I will furnish a guarantee for the entire amount. That in the event it is found that the plaintiff is entitled to the money that he has sought for in the plaint on the basis of bank guarantee, please grant me my prayer under 52.
Yes.
I will do it. But what more is this? This is why, my lord, the trial court is completely wrong in granting the order of injunction. And order 6 rule 17 could not have been granted.
Yes.
And your lordship may kindly see, my lord, our objections at page 389 to the application for amendment of the plate. 381. If your lordships are kind enough, my lord, to turn to page 385.
Yes.
Paragraph number 8.
385.
Yes, sir. 385.
385 is.
My objection to the application filed by the plaintiff under order 6 rule 17. Para 8.
385 is something else. You know, Nelamangala.
My lord, I'm sorry. Yes, I'm sorry. 434, my lord, I'm sorry. I was referring to the page number in the petition, I'm sorry. Para 8, if your lordship is kind. 434. Relevant date 438 and para 8.
Yes. Yes.
It is submitted.
Yes.
It is submitted that plaintiff has further sought for insertion of a prayer to cancel the sale deed executed on 15/6/2021 by plaintiff in favor of the defendant and declared that the sale deed is not binding on the plaintiff. It is submitted that the amendment sought for inclusion of a prayer is wholly erroneous since it would change the nature of the present suit. The plaintiff has filed the present suit seeking for specific performance of the agreement to sell dated 28/3/2017. By way of present amendment, plaintiff now seeks to add a relief of cancellation to cancel the sale deed and so and so and declare relief that the sale deed is not binding on the plaintiff. It is pertinent to submit that the agreement of sale has culminated in the sale deed dated 15/6/2021. Plaintiff cannot seek inclusion of additional prayer arising from a separate cause of action. If the plaintiff is agreed with the executive sale deed, he ought to file a separate suit, etc. The nature of the suit will completely change from a suit for specific performance to a suit for cancellation. In fact, it is a suit for money. You call it whatever you want. They may call it as a direct specific performance of the agreement that so and so and direct them to pay. It's ultimately a suit for money. That's a prayer your lordship saw, my lord. And now, my lord, your lordship may kindly see the order that has been passed in this case. On IA 1 and 2, if your lordships are kind enough, my lord, to turn to page 46. 46. That is the order, my lord, granting the injunction.
Yes.
Which is the one, my lord, which is subject matter of the MFA before your lordships.
Yes.
I'm going to, my lord, I have point out your lordships, my lord, all the facts. I hope
Yes.
to trouble your lordships. Kindly turn to page number 58. The reasons, my lord.
Yes.
The plaintiff has filed this suit for relief of specific performance to direct the defendant to perform its part of the contract as per clause 7 of agreement of sale dated so and so by paying balance consideration of 21 crores and to pay amount of 4 crores 48 lakhs towards expenses order of conversion and also in failure on the part of the defendant to perform same to declare power of attorney dated 10/4/2020 and to declare the supplemental agreement dated 10/1/2020 as null and void. So it is really, my lord, a relief if you don't pay the money. Further, the plaintiff has also filed IA number 1 under Order 6/17, seeking leave of this court for permission to amend the plaint, wherein he has sought relief of cancellation. Further, he has also filed IA number 2 under Order 39 Rule 1 and 2 of CPC to restrain the defendant and anybody related to the defendant from alienating the suit's property. In order to obtain relief of temporary injunction, the plaintiff has to establish prima facie case in his favor, and in order to appreciate what amounts to prima facie case, it is worthwhile to rely on the judgment of the Honorable Supreme Court in so and so, so and so. Not all the now kindly turn to para 20. In this case,
Yes.
it is the contention of the defendant that the suit of the plaintiff in substance is only for recovery of money. Further, as per prayer number 1, no doubt the plaintiff has sought prayer to direct defendant to pay the money. But if entire prayer is taken into consideration, then no doubt the main relief is with respect to payment of money. But other relief, though consequential in nature, avoids contact between plaintiff and defendant if the said amount is not paid. My lord, if this is the understanding of the learned trial court, and I think it is right, the conclusion should have been different.
Yes, only payment, direction to pay that amount.
Exactly. Where is the question of saying don't alienate the property? This reasoning in para 29 is correct, my lord.
Yes.
But unfortunately, the conclusion is wrong. Then, my lord, please see how the trial court approaches the matter. Further, as per say of defendant, entire sale consideration is already paid. But as per say of the plaintiff, defendant has still to pay portion of sale consideration and other expenses. Further, it is the contention of the plaintiff that as per the original agreement, the sale consideration was fixed at a higher rate and defendant by coercion had obtained another supplemental agreement. I pause for a moment here, my lord, to point out to your lordship that the risk of repetition, and I seek your lordship's pardon for it, that the agreements of sale are not under challenge. None of the agreements of sale are under challenge. They are all registered supplemental agreements. None of them are under challenge. Amounts have been paid by check. Amounts paid not in dispute.
Yes.
Further, it is a claim of the defendant that the power of attorney dated 10/1/2020 is a irrevocable power of attorney, and on the basis of the same, he has executed his sale deed dated 15/6/2021, and according to the plaintiff, the same is irrevocable only if balance sale consideration is paid, and in this state, we peruse condition number 3Y of the photocopy of the power of attorney, then the same goes to show that the same is irrevocable only after payment of balance consideration, and for that reason, the above contention cannot be carried at this stage, and that for that reason, the same requires trial, and according to the plaintiff has got prima facie case in his favor. My lord, even the power of attorney revocation under prayer number A in the plaint, which remains intact, is only if you don't pay this, I will revoke it. Please revoke the power. So today, my lord, I am willing to say, I will give a bank guarantee for them. Let us put a quiet test. If his money is, if he is entitled, let him prove, my lord, that he is entitled to this 21 crores, let him get it. If I am able to show no, nothing is payable, let's send him and get my bank guarantee back. Why I ask myself, my money of 82 crores, 75 lakhs be in his pocket? I, who have a valid sale deed in my favor dated 15/6/2021, which is not hit by any principle of law.
Yes.
Why should I be deprived? I ask myself of my right to use the property as owner of the property. I can sell it, I can develop it, I can do whatever I want. His fear is I may not pay this money of 21 crores, I will give a bank. Note it.
Yes.
And then kindly see, my lord. Request, right? And according to plaintiff has got prima facie case. I mean, how does the plaintiff have a prima facie case in respect of a property when the subject matter of the suit is only for recovery of money?
Yes.
Well, this goes against the fundamental principles of grant of injunction. Injunction can be granted only in a situation where compensation in terms of money cannot adequately compensate the plaintiff. Where is giving money? Whether he is entitled to money or not, the matter to be proved. How I ask myself is this in respect of a property? Just because he makes an application, the suit is for money, application for injunction is in respect of property. Therefore, my respectful submission is that the application, under Order 6, Rule 17 will be dismissed on the ground that it changes the cause of action of the suit from one for specific performance to one for cancellation. Injunction granted is wrong, and please grant me permission under Section 52. It's a classic case. I am willing to furnish, my lord, whatever security you are not think is appropriate. I am willing to do it. No difficult. But now kindly see para 35, how it deals with how the trial court deals with my application under Section 52. Please be kind enough to turn to para 34.
Yes.
In this case, the defendant is seeking permission of the court to alienate sites formed in the suitable property subject to terms and conditions which may be imposed by the court. And the plaintiff is seeking temporary injunction not to alienate such sites. Further, if intention of both the parties is used on the basis of material on record, balance of convenience lies in favor of the plaintiff rather than the defendant for the reason that as per schedule IA number 2, there are about 20 properties, and if court allows IA number 3, and the properties are sold in favor of third parties, and later plaintiff succeeds in the suit, not with respect to recovery of money but with respect to reliefs, declaration of power of attorney null and void, and also cancellation of sale deed, then the plaintiff has to file a suit against each of every purchaser who has purchased the site, which will be difficult for the plaintiff. First, my lord, that approach itself is wrong because the court would have very well said, all right, prima facie determine as to whether the plaintiff is entitled to the money or not. If the court came to the conclusion that prima facie, yes, I think the total consideration was 102 crores 6 lakhs 25,000 and it was not reduced to 90 crores 42 lakhs, and that the agreement dated 10/1/2020, which is not challenged. That's the most crucial point which the learned trial court has omitted to take into account.
Yes.
The agreement of 10/1/2020, the Lordship will kindly see the list of dates for all. The first is date on page number 4 of my list of dates. That's a crucial document, to which I respectfully submit that the trial court has not applied its mind, which is an undisputed document.
Yes.
90 crores 42 lakhs is the consideration, out of which, my lords, admittedly, we have paid 82.75 crores, which leaves a balance of 7.67 crores. Therefore, my lord, I would say, please direct me to furnish a bank guarantee for 7.67 crores, I will do it. Let us go on with the admitted facts. Keep the disputed facts away, which is what, my lord, your lordships have held at the time of granting temporary injunction. Don't go into disputed questions of fact, don't go into a mini trial. Very well, I go down to all the principles. Let us go on with the admitted fact. Agreement dated 10/1/2020 not challenged. Under that agreement, the consideration is 90 crores 42 lakhs. Admitted amount paid is 82 crores 75 lakhs. Balance consideration therefore is 7 crores 67 lakhs. I'm reading your bank. He has to prove coercion or whatever. In any event, there is no relief. There is no relief. Simply making a general statement of coercion is no good. This is that now. This is my submission, my lord. All this. Now, my lord, I just want to place for your lordship consideration 3 judgments on 52. In fact, I must tell you, lordship, the 52, the proviso, the judgments are scarce. There are not too many.
I will hear him regarding 52 because I am hearing only for the interim order. I am not deciding that
Yes,
matter.
grant me permission.
Only interim. Then we will see that whether 52 has to be considered or not. After hearing them only, I will see that.
Of course.
Yes. No.
Just not.
No. All considering only for interim order. I am not deciding that matter on 9 because it requires much time to decide. Therefore, regarding that interim applications he has filed.
I have filed an application for stay of injunction. If stay of injunction is granted, then my lord, grant me interim provision for 52. I will give a bank guarantee for 7 crores.
That after hearing that,
yes.
therefore, it is not that main matter. Yes.
No, may be necessary for the simple. That courts when it grants an expired order, necessary order will be written based on. Here a considered order is made. When a considered order is made, the court will look into the plain, the written statement, and the documents produced by both the parties. So here, I may have to take the court through the plain because the foundation is laid in the plain for the grant of an interim order of injunction.
Yes.
So the paragraphs of the plain in order to establish this is a sort of the contract because the plaintiff was under a lot of financial stress. He entered into this agreement to sell his valuable property only for that simple reason. And
only
the
thing
monies
is,
were not paid on
you have to make out prima. You have
Yes.
to submit that prima facie case is made out. Therefore, injunction granted is correct.
Take the court through certain paragraphs of plain number 1. Number 2, interference by the court in a miscellaneous first appeal is very much limited in my experience.
Yes, that.
Because unless the order is perverse or wholly illegal, this court will not interfere. That is number 2. Number 3, on 52, actually they have themselves already played fraud because that suit was pending as on that date. I take the court for my benefit through section 52 once again. As on that date, admittedly,
Yes.
the suit was pending. Finally, the plaint may have been rejected.
Yes.
But the court said you present the other plaint. It is not it is a continuation.
Yes.
So in the circumstances, already when a person has approached the court with unclean hands, will be entitled to immunity and thanks of this. That is number 4. Then the next one would be as on the date the judge passed the orders on the application under 52 and order and the application and order 39. They had already allowed the amendment. The amendment application had already been allowed. He refers to that in the order that is passed, which I take to prove. So as on that day, there was a prayer for cancellation of the same. And
No, that as on that day passing an order, writ petition is already filed.
writ petition is not.
Challenging that amendment. When that amendment has been allowed.
Logically, my friend has missed out some of the prayers. Let me read. Leaving out that out of the cancellation of the same date, the other prayers. Because he said supplemental agreement, they are not sought for
Yes.
cancellation. They are sought for a declaration in that.
reference to the earlier suit and all that is of no consequence. Ultimately, everything has been set at rest.
Yes.
The suit has been filed, which was proper, and on that an adjudication has been made by the court after hearing both the parties.
Yes.
Now kindly take the prayer, I don't know, I'm reading from the appeal,
Yes.
page 199, prayer portion of the plate. Appeal number of the amendment.
Yes. 199.
It's easier.
Yes.
The first prayer is to direct the defendant to perform his part of the contract as per clause 7 of the agreement of sale dated 28/3/2017 and pay the balance consideration of rupees so and so, and to pay an amount of rupees 4.48 lakhs towards reimbursement of the expenses incurred by the plaintiff in securing the change of land use as agreed to by the defendant under clause 3F of the agreement of sale dated 28/3/2017 and conversion of land to the new old tree. Not the current tree. You are reading the old legal again. No, sir. 329. You are reading plain, just rejected. You may read page 329.
Yeah, that's what.
329. I read from 320. It's the same thing.
No, right. No, let's be clear on that.
I read this one.
Okay.
If you feel that there is any doubt, of course, to direct the defendant.
No. Which page 3?
Page 329.
329. That is the plain in suit.
Yes.
Now,
Yes.
Amendment has been allowed.
Yes.
To direct the defendant to perform its part of the contract as per clause 7 of the agreement of sale dated 28/3/2017. Pay the balance sale consideration of rupees 21,66,000. 21 crores 66 lakhs 30,556 and to pay an amount of rupees 4 crores 48 lakhs towards reimbursement of the expenses incurred by the plaintiff in securing the change of land use as agreed to by the defendant under clause 3F of the agreement of sale dated 28/3/2017. Conversion of land and in the event of failure of the part of the defendant to comply with the sale, declare the power of attorney dated 10/1/2020 executed by the plaintiff in favor of the defendant registered as so and so in book number so and so before the sub-registrar Delman Law as null and void. To declare that all acts, deeds and things carried out by the defendant under the power of attorney as invalid and not binding on the plaintiff.
No, that 10/1/2020 is on the basis of the GPA.
That is GPA. See, even if that amendment was not allowed, say if I not even filed for amendment, with according to my respectful submission is that this prayer too would cover even that, because to declare that all acts, deeds and things carried out by the defendant under the power of attorney as invalid and not binding on the plaintiff. That sale deed is in pursuance of the power of attorney. Apart from the fact that the sale deed is fixed by dispendence, which I will be able to satisfy this one with court. Apart from that, even this prayer would cover that sale.
Letter 10/1/2020.
10/1/20. I'll take the court to the power of attorney.
Yes.
To declare that all persons acting upon the power of attorney shall with immediate effect cease to have any rights or interest in respect to the suit scheduled property conferred upon them by the power of attorney. Or to declare the supplemental agreement dated 10/1/2020 entered into between the plaintiff and the defendant as null and void.
No, that 10/1/2020 is that that is what that is.
No prayer has been
Oh,
made.
that is. Yes. No, you said that this is not challenged. This is the.
What is granted? But
No.
all these are, if you don't pay this money, then these things will follow. That is
The
all.
other says if the sale deed is cancelled, then nothing would survive. How can I sell anything? All those sale which are stated.
No, that's why you have sought first prayer.
We have
You
sought
could-
for the first prayer,
Hmm.
fine, but still there are other ancillary.
No, that is
prayers.
true. That is. See.
The prayers will have to be considered as a whole, and the courts finally look into the fact whether they can mount the relief in order.
No, as you said, alternative. Amount of towards reimbursement so and so and conversion large so and so.
In the event of failure,
Andhra, it is like an alternative prayer.
it's like an alternative. But that is not the only prayer.
No, when you have concentrating on that sale deed which is obtained from you, no, you should have say first prayer should be cancellation. If fail to establish for cancellation, then you are entitled. That should be that.
They had not known that time this when the claim was filed. Possibly they had no knowledge of the same. That was how the claim was drafted. I am not the author of the claim.
No, but they have said subsequent sale also.
So all subsequent acts and that. If there was a sale, they would have specifically made a prayer. The prayer that has been was in the earlier suit has been repeated here. That is the unfortunate.
They did not amend prayer number 1.
Declare this, then the next one.
No, you should have seek for an amendment of prayer. Seeing that that has to be delete. You have sought for a delete and you have to say only for cancellation. If you are sure.
Only for cancellation ಅಂದ್ರೆ ಇವಾಗ ಇಷ್ಟೆಲ್ಲ ಹೇಳಿ ನೀವು ಎಂಟು prayer ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ ಆದ್ರೆ
Alalala. See, asking the prayer is also different. If you are seeking, it is an alternative prayer, then it is different.
Unfortunately, you have to go by what.
Yes, yes, that is true. But the way it has been pleaded,
The court of the advocates who appear is very much limited because we'll have to go right now. I cannot possibly take amends for what has already been done.
yes, yes,
But I am saying this prayer only justified.
yes.
Because I will take the court through the claim. The circumstances which drove the plaintiff to sell the property are stated very, very clearly. And as to how he was coerced by the defendant, time and again. And monies were not paid in time. To direct the defendant to pay some of rupees 4 crores as compensation to the plaintiff as a result of loss of property in the business of the company due to the non-compliance with the agreements by the defendant, medical expenses and legal expenses. To pass any such orders. Now kindly take the plaintiff. Starts, I read from this one, page 380. Paragraph 4 and page 319.
Yes,
Paragraph 4.
yes.
Plaintiff was struggling to continue the business and repay the loans to the financial institution. Before that, I read the earlier paragraph. Plaintiff is a successful businessman with commendable business etiquette and great reputation in the field of business. The plaintiff has received appreciation letters from KCC and Eligible requested to serve on its beneficiary board. The plaintiff's business took a hit in 2013 and incurred huge loss. The plaintiff therefore was forced to avail financial assistance to continue the business. The plaintiff was struggling to continue the business.
No, plaintiff is an individual or a company? Company, individual.
The plaintiff was struggling to continue the business and repay the loan to the financial institution. Such sort of agreements where one party is not in a position to bargain, unequal bargaining power is there.
Yes.
Supreme Court has said these are contracts where take it or leave. This is a similar sort. I would lay a foundation to establish that this is a contract which was take it or leave. I was in a financial stress. I had a lot of loans. I had to repay. My factory would be taken over. Ultimately, it was taken over thanks to they say the efforts of the defendant in delaying to pay the money.
No, ultimately in the first agreement, you have agreed for 100 crores.
102 crores.
Why can't you settle that negotiation with that parties instead of that? Anyhow, you want to sell. Only thing is that difference of.
They defend the other amounts which they have spent towards.
You said, just said 4 crores. When you both are making a transaction of crores, 4 crores is nothing.
ಅಲ್ಲ ಇವ್ರಿಗೆ ಸ್ವಂತ ದುಡ್ಡಲ್ಲ ಲೋನ್ ರೀಪೇ ಮಾಡ್ಲಿಕ್ಕೆ even those documents are produced. Even those documents are produced. His factory was auctioned because he didn't pay.
No, all that is over. Now, in respect of this disputes, if appears to be that for the money, anyhow, you are then a landowner, you want to sell somebody else. Why can't you settle that?
Settle ಅಂದ್ರೆ Finally, a quietness has to be. Let them come up with a good offer of about 20 crores and odd is bid, because 4 acres of land was further leaving. That is why I am saying that there was a question where this plaintiff did not have any choice, he had no bargaining power with the defendant. And the defendant is a big company. Even according to my friend would agree, they are a huge company. Whereas this man is an individual who has come knocking on the doors of the court because of the fact that he was very difficult. In the circumstances, if a
No, I'm saying that he himself has agreed for some amount. Later, their contention is that extent of the land has been reduced. No, but
if they suffer losses, if they
no, that it is an admitted fact that 80 crores is already paid.
82 crores is all.
Then remaining is not much.
So much of
If
land.
no amount is so much.
No, that they are not disputing 80. But then the consideration that was agreed was 102 crores. Further
No,
land was offered.
Is it possible for any settlement? Otherwise, I will hear that.
In fact, it was referred for settlement, we went for mediation, or they never turned up. So, my lord, it's I think they're spending time, my lord, it's not going to use. No, I'm not saying. What happened? Your lordships, when it came up before your lordships on the earlier occasion, respectfully, my lord, 1 minute, let me complete. Let me complete, my lord, they did not, so my lord, I think the mediation is not going in. So, but
That was quoted by.
my lord, that's all right, my lord,
Thanks for not agreeable.
No, that, yes, if you are not agreeable, then yes. Yes. Yes, yes.
The plaintiff was struggling to continue the business and repay the loan to the financial institutions. But this was the situation, financial institutions put additional burden on the plaintiff, demanding repayment of the loan. In order to maintain credibility and creditworthiness and protect the reputation of the business, the plaintiff decided to offer the suitable property sale to the public. The plaintiff received multiple offers from several prospective purchasers and builders who were interested in purchasing the suitable property. At this juncture, the defendant approached the plaintiff by stating that he was a reputed property developer with enormous financial capacity and enjoyed an excellent reputation in the market and made an offer for purchase of the suitable property by expressly stating and assuring the plaintiff that the payment of the total sale price and consideration would be made within the time agreed upon without any delay or deferment whatsoever. The plaintiff had decided to offer the suitable property for sale for the sole reason that he could then clear the company in use and restart the business. The plaintiff was hopeful that with the sale consideration amount, he could repay and clear his financial obligation. The plaintiff thus yielded to the constant and persistent follow-up promises and assurances to the defendant, and finally agreed to sell the suitable property to the defendant with the belief that the sole consideration would sale consideration would release him from his financial obligations. The plaintiff's primary intention to agree to sell the suitable property to the defendant was so that he could then clear his outstanding dues with the financial institution from whom he had availed loans. At that point of time, the plaintiff was not aware that the defendant would deliberately put the plaintiff into extreme hardship by unnecessarily delaying the payment of the sale consideration and the execution of the sale deed. An agreement of sale was entered into between the plaintiff and the defendant dated 28 March 2017. The agreement of sale in unequivocal terms contained that the plaintiff is the absolute owner of the scheduled property and the sale consideration of rupees 102 crores 6,25,000 was fixed. Rupees 2 crore 30 lakhs per acre. A certified copy of the agreement is also. Subsequent to the execution of the agreement of sale, upon instructions from the defendant's legal counsel, the defendant sent out a requisition list insisting the plaintiff to comply with a number of obligations before the execution of the sale deed, which were never agreed to by the plaintiff at any point of time whatsoever. The elaborate requisition list as per the defendant's email dated 17/6/2019 was no part of the initial discussions or the conditions of sale. The requisition list contained acts which were required to be done by the plaintiff, which were never a part of but rather contrary to the terms contained in the agreement dated 28/3/2017, entered into between the plaintiff and the defendant. The plaintiff, upon the request by the defendant in good faith and to maintain the business relationship with the defendant, agreed to comply and complete all the supposed obligations imposed upon by the plaintiff, by the defendant. Despite these obligations not being a part of the agreement of sale and having come up subsequently, the plaintiff also wanted to complete the sale transaction without any obstacles, so that he could in turn clear the company loans. The requisition list sent by the defendant required the plaintiff to obtain deeds of confirmation of release from the family members of the predecessors in title of the suit. The plaintiff had repeatedly reiterated that this exercise was legally not required and was resulting in substantial, unforeseen, uncalled for, and unnecessary expenditure on the plaintiff, which was an additional financial strain on the plaintiff. Yet, due to the pressure from the defendant, the confirmation and release deeds were executed and registered in October 2017 and November 2017, respectively. Further, among the other obligations cast on the plaintiff, the defendant also required the plaintiff to obtain the change of land use from the Nirmangala Town Planning Authority, which also resulted in substantial expenditure being incurred by the plaintiff. In fact, the substantial costs incurred for obtaining the change of land use by the plaintiff was agreed to be paid by the defendant, in addition to the sale consideration, sale price, and consideration payable to the plaintiff. But till date, it has not been reimbursed. The plaintiff also expressed the difficulty he was facing to obtain change of land use, as Karnataka state elections were due and the government authorities were preoccupied with the preparations. The defendant showed no concern for the same. Copy of the letter dated so is attached. It is pertinent to note that the plaintiff kept the defendant updated on a regular basis with respect to the progress in completion of the supposed obligations by various emails. The plaintiff, despite the fact that he was not obligated under the agreement of sale or under any agreement to fulfill the requisition list, undertook to fulfill the obligations to the requisition list for the sole reason of preserving good business relationship with the defendant. The plaintiff obliged to fulfill the conditions insisted by the defendant in the requisition list, which were never agreed upon by the plaintiff, despite knowing fully well that the fulfillment of the obligations would cause considerable delay in completing the sale and would cross the deadline as per the agreement dated 28/3/2017. The defendant not only sent the requisition list to the plaintiff to fulfill, also addressed repeated representation to the plaintiff that further payments towards the sale price and consideration would be made only against and subject to the plaintiff performing the obligations to the satisfaction of the defendant. Instead of supporting the plaintiff for obliging to complete the supposed obligation, the defendant shockingly decided to inflict more trouble on the plaintiff by repeatedly demanding payment of interest on the money advanced by the defendant, which is in fact illegal. The plaintiff requested the defendant to pay the sale consideration amounts in installments, as he needed the money to fulfill the obligations laid down by the defendant on the plaintiff. The defendant conveniently failed to understand that the plaintiff required the money to fulfill the requisition list sent by the defendant and not for any other purpose. Clause 3 of the agreement of sale states that the cost of change of land use up to 13 acres of the scheduled property shall be fully paid for by the purchaser, that is the defendant herein, and subsequently up to 15 acres. Therefore, as per the agreement, the defendant was bound to release payments to the plaintiff to undertake the task of obtaining the change of land use. The defendant conveniently displayed to the plaintiff that it was advancing the money from the sale consideration without even mentioning cost to be borne or paid by the defendant for obtaining the change of land use. Not only did the defendant deceive the plaintiff by not complying with the agreement, but also imposed interest on money advance. The defendant failed to consider that as per the agreement, it was bound to pay for all expenses borne by the plaintiff for completing the work. Clause G and H of the agreement of sale regarding the payment of interest by the plaintiff on the advance amount given by the defendant until the plaintiff obtains the conversion order, and the new timelines in case of any delay in obtaining conversion, respectively, are contingent upon the performance of clause F by the defendant. That is the payment of cost incurred by the plaintiff for obtaining the conversion. The defendant without complying with clause F conveniently invoked clause T and F and made it seem like it was doing the plaintiff a favor by making the advance payment. The plaintiff by email dated 30th July 2019 sent a detailed report to the defendant with respect to the substantial completion of its supposed obligation. The plaintiff, without complaining about the substantial cost incurred by him to complete all the obligations imposed by the defendant, informed the defendant about the stage of completion of the obligations. The plaintiff reminded the defendant that the expenses incurred by him to complete the obligations imposed would have been paid by the defendant as agreed upon under the agreement dated 28/3/2017. The plaintiff clearly stated in the email that the defendant's demand for the payment of interest on supposed delay on the plaintiff's part was illegal and unethical and would not be entertained. Instead of acknowledging the trouble taken by the plaintiff to complete the obligations imposed by the defendant upon the insistence of the defendant's legal counsel, the defendant persisted in demanding the interest. The defendant sent an email dated 1/9/2019 stating that an alleged interest amount of the money advanced by the defendant was accumulated, and therefore the defendant had not intimated any further payment to the plaintiff towards the sale consideration. Subsequently, while email dated 6/9/2019, the plaintiff responded to the email dated 1/9/2019. The plaintiff reiterated that he did not wish to engage in any further conversation regarding the payment of interest, as it had been clearly addressed in his email dated 30th July 2019. It is evident that the outrageous claim of interest, as demanded by the plaintiff defendant, was only a delay tactics in order to buy further time for completion of the sale, as the defendant was quite obviously not in a financial position to complete its end of the contract. Additionally, in the year 2016, the plaintiff handed over all the original documents of the suit schedule property to the defendant. There was no requirement for the plaintiff to hand over the original documents. Yet, upon demand by the defendant, the plaintiff handed over the documents. The plaintiff, even in the absence of the original documents, succeeded in fulfilling the obligations as per the requisition list of the defendant, which required constant follow-ups with the government authorities. It is pertinent to note that realizing that this tactic of interest claims would not last too long, the defendant next decided to convince the plaintiff into agreeing to a reduced sale consideration by stating and insisting that any further payment would be made only against the plaintiff signing a supplementary agreement accepting the reduced sale price and consideration. This is the foundation that is laid.
Yes.
Or as to why the supplemental agreement is. They are seeking it to be another. Plaintiff submits that the sale consideration of rupees 102 crores 6,25,000 as per the agreement of sale was forced to be reduced by the defendant using arm twisting tactics. Despite the defendant's inconsiderate and illegal stance as displayed above, upon demand to reduce the sale consideration, plaintiff yielded to the demand and agreed to enter into a supplemental agreement under duress. The plaintiff's company was also under the pressure of recovery proceedings initiated by the financial institutions. This situation of recovery proceedings would not have arisen had the defendant made the payment of sale consideration within the stipulated time and completed the sale transaction. Accordingly, a supplemental agreement dated 10/1/2020 was executed between the plaintiff and the defendant. Thereby, the sale consideration was reduced to 90 crores 42 lakhs. As per the supplemental agreement, the total extent of the scheduled property was increased by 1 acre 1 gunta, totaling to 45 acres 16 guntas. Accordingly, the total sale consideration should have been rupees 104 crores 42 lakhs. The defendant conveniently ignored the increase in the sale consideration and continued to retain 102 crores 6,25,000 as the sale consideration from the above. Rupees so the defendant conveniently reduced 14 crores as alleged interest towards the amounts advanced by the defendant in then. Therefore, the defendant has failed to take into consideration the difference amount of rupees 2 crores 35 lakhs 75,000. In the said supplemental agreement, it was agreed to by both the parties that out of the sale consideration of rupees 90 crores 42 lakhs, rupees 56 crores and an additional amount of rupees 12 crores had been paid by the defendant, which had been acknowledged by the plaintiff. And accordingly, a balance of rupees 22 crores 40 lakhs remained outstanding from the defendant paid to the plaintiff. The supplemental agreement completely in favor of the defendant not only reduced the sale consideration, but also increased the extent in the suit scheduled property. After mutual negotiations, the total extent of the suit scheduled property was increased to 47 acres and 15 and a half gutas without any corresponding increase in the sale price and consideration. Pause here.
What is that earlier extent first? 45.
Extent was 45 acres, 16 acres. 102.
No, that earlier they said 52 acres. That synopsis. In synopsis, they have produced first on 1/6/2006.
Was entered in the earlier agreement in 2000.
No, that's what he's saying, that area has been reduced. You are saying that area has been increased. Therefore, it is confusing for me whether it is increased or reduced.
2017 agreement,
Yes.
which is not challenged. I am repeating it for my learned friend's benefit, my lord.
Yes.
2017 agreement is not challenged. There, the extent was 44 acres and 15 guntas, as opposed to the earlier extent of 52 acres. But this is all admitted facts. This agreement of 28.3, I don't think my learned friend contradict me, has not been challenged.
I like to say all that is stated in the plate also is admitted facts.
No, I am just asking. No, you are saying that area has been increased. He said that decreased. Therefore, I want to clarify. Yes, yes. Yes, just you clarify that. Why that difference?
See page 150.
Yes.
Page 150.
Yes.
This agreement of 28.3.
The consideration sale price for the sale of the scheduled property is 102 crores 6 lakh 25,000, calculated at rupees 30 lakhs per acre for total land area of 44 acres 15 gutas.
44 acres, 15 guntas. That is also he has referred. First he said it is 52. Is it true? Which is that agreement to sale dated 1/6/2016.
Page 67.
Now the defendant is supplied first.
Allah, is it?
Agreement to sell is 2017. 28 March 2017. ಅದರ ಪ್ರಕಾರ 44 ಎಕರೆ 15 102 crores 6 lakhs 25,000 for 44 acres 15.
Yes. Yes, 44 acres, 15 guntas, 102 crores. Yes. When it is increased, reduce ಮಾಡಿ.
40 lakhs there. 47 acres 15 and a half crores.
That according to you, it has been increased to 47 acres. No, when that agreement for 47 acres?
2020 supplemental agreement. Page 139. 139. Regular. 47 acres, 15.5 hectares.
What is that consideration? Here,
This is 92 crores.
well, again it is reduced.
Reduce. Reduce Madhya. This is also what my friend was saying. This also it seems strange.
No, that trial court will decide why it is reduced. Whether is there any coercion, influence and all. That I can't.
Pending properties, different surveillance. Tomorrow is my prayers in the suit. Because an amendment can be allowed any time.
No, I'm not on that amendment.
No, I'm saying,
Yes.
there is a prayer now for cancellation of the sale deed. Firstly, the sale deed is executed at a time when that suit was pending. Suit was not disposed of. I will take a court through section. My respectful submission to the court would be that sale is hit first by misspending. Number two, if tomorrow the sale deed is set aside by the trial court, then what happens to all those people to whom they have sold?
That is their risk. Their risk.
In the circumstances, this honorable court will have to direct the trial court to dispose.
No,
of
that
the suit
Supreme
within
Court
the-
said when that so many, he has invested so many amounts, it is under construction, said that even in the sale, Supreme Court said in the sale deed, you have to mention that there is a pendency of the case. If parties agree to purchase, it is for their fate. That is what the Supreme Court said.
Tomorrow if it is.
No, if they are purchased, they see, suppose tomorrow your suit is dismissed, then
That is not possible because under RERA also, they have to every quarterly statement. They have to disclose that there are litigations pending. Immediately litigations are pending, then they.
no, that is not that. When he has invested so much of money, ultimately, if it is succeeded also, that it can be compensated by money.
I will give a bank guarantee for the entire, but all this controversy, I will give a bank
Then-
guarantee for the entire amount.
Then even day after tomorrow also, I have passed that one order where senior counsel Naganand and others is. I said that in the sale deed also, they have to mention regarding the pendency of the case.
No problem. And I will give a bank guarantee for.
And
the
also I'll
entire
direct the trial court to dispose of as expeditiously as.
For 22 crores which he is claiming, I will give a bank guarantee.
Very 22 crores.
Indian is there. 4 crores is a dispute. 4 crores is a, he said expenditure. Let him prove it. Let him prove it. Let him prove that. But today, that 4 crores is a matter. But 4 crores.
See 80 plus 102. And
22 crores. Let's go back.
30 crores, let him give a bank guarantee. 30 crores, let him give a bank guarantee. Let him start construction.
We'll do it.
Then if he want to alienate, he has to mention the pendency of the case. Monday. Yes. Or if it is possible, both of them ready to settle for one for all. It is for also is good.
You are the person.
See,
You are the
you are the landowner wants to sell that. He wants to develop. He wants property. You want money. Then only the difference of money. No, that's what. No, not that. You have to put. No, you want to put that same problem with them. What are the loss you have caused? You may also.
Lord, kindly see, my lord, after the 10-1-2020, which is about which so much. I think I 1 minute. 1 minute. Well, now you may don't ask me that question. Ask your client that question. I'm sorry, not ask.
It's Monday.
The client was the one who walked out of the mediation. They walked out. They said, we are not agreeable. I am not agreeable. That's the instruction. That's my.
Monday. Yes.
No, I am not agreeing to, but instruction. Both of us acting on instructions. But kindly see, my lord, there's on the face of it. After 10-1-2020, there has been at least 10 additional payments that have been made. He takes the money, 52 crores have been paid. He takes it quietly. Happily, he takes the money from me. And no protest. Today, suddenly,
He's saying that because of payment, delay in payment, he lost some business.
He should have said, I don't want your money, I'm cancelling the agreement. He's entitled to it. He did not. He stood by it, took the money, happily got 82 crores, 75 lakhs, put it in his pocket, and then suddenly files his, and then says, get it in cash. Otherwise, now we have.
They want
Sorry,
property.
what the property? Sorry, no, no, injunction must go. The injunction must go.
That we'll see that. Yes, Monday you verify that.
Monday I will verify.
Yes. This matter on Monday.
Number 69 attempt, number 70, Abhinav Ramanand here for appellant. Yashud Gupta.
Mara.
ಅಲ್ಲ ನಾಳೆ ತಗೊಳ್ಳಿ ತೊಂದ್ರೆ ಇಲ್ಲ ನಾಳೆ ಸ್ವಲ್ಪ ಮೇಲೆ ಇಟ್ಬಿಟ್ರೆ
ಬರುತ್ತೆ ಹಿಂಗೆ I don't know.
ಅಲ್ಲ
So more than 10 matters, all senior counsels have argued little and then taken adjournment. See, if it is one stretch, it is argued. It's and these are all only on that application, interim application.
ಅದಕ್ಕೆ ಅಂದ್ರೆ ನಾಳೆಗೆ ನಾವು ಮಾಡ್ತೀವಿ. ಈಗ
Now that you have not completed,
ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ, ನನಗೂ ಇನ್ನೊಂದು 15-20 ನಿಮಿಷ
you complete that. You complete. Let us see his argument later.
So, even for J.D. Surana, the notice was, as I pointed out, only one notice without reference that the order refers to all the both two companies and one proprietary concern.
Yes.
With regard to the one where they have referred, even with regard to the 2611 notice.
Yes.
That would be page 57 in the documents given by us. Page 748.
Yes.
It is addressed to Shri J.B. Surana, Director, Precision Granite Marble Private Limited.
Yes.
Even here, on the other hand, it should have been to the company, represented by any director. It need not, J.B. Surana is not managing director or anything.
Yes.
Of course, they had issued notice to him because he had filed the writ petition, J.B. Surana.
Yes.
It's only on that ground that they have made J.B. Surana as the representative.
Yes.
Would have been anybody, any other director would have come.
Yes.
Even that notice is by responsible submission is defective.
Yes.
But this is the only notice.
Yes.
Now, the court below passes the order.
No, this is even consider that for the company, it is only respect of one company.
One company, the notice, considering it as one company Precision.
Yes.
Though it is defective even for that company.
Yes.
Because probably if it were to be addressed in the name of the company,
Yes.
any other director would have represented. This submission I am making because there is an observation in the order by the court below saying other directors of the company should have condemned the actions of J.B. Surana.
They have to take action. But they, yes.
Correct.
If they were to take action, notice should have been the other.
No, it is for that companies to take an action against that Surana because if he is violated any this thing. Not for the federation.
With this reference, kindly see that order dated 15/7/23, which is communicated to us. 22,
Yes.
which is communicated to us, that is page 51. It starts at page 51.
In page,
That starts at page 51.
in appeal memo.
ನಾನು ಕೊಟ್ಟಿರೋ appeal ಇದೆ ಅದು, but
Yes, yes.
composition ನಲ್ಲೇ ನೋಡಿ.
Yes, page.
It starts at page 51.
Yes,
That is the communication of disqualification which is sent.
yes,
15.
yes, 51.
20.
Yes,
Really, you will also kindly come to page 54. After quoting 7.8G and 7.8H,
yes,
kindly see. The acts of J.B. Surana is nothing but to be disruptive to the federation, apart from causing financial losses to the federation. The disability committee formed effects of the federation, and after having found guilty of 7.8G and H, went on to recommend disqualification from the primary life membership of the federation. Further, disciplinary committee made the recommendation that act of J.B. Surana is nothing but his intention to disrupt the activities of the federation, to cause unwarranted concern and disharmony among the members of the federation, to tarnish the image of the federation, and to bring disruption to the office panels, executive committee, president, general secretary, which are in clear violation of clause 7.8H and G of the bylaws, apart from causing huge financial loss of the federation in fighting unwarranted and frivolous litigation, in spite of no grievance having been made out. J.B. Surana, former president, is a life member in Precision Granite Marble Limited, Surana Fabricators Private Limited, Surana Stores Limited. In LM number so and so, J.B. Surana is director of the company. In LM number so and so, managing director of the company, and a proprietor in firm number so and so. Even though this sentence, even though there are other directors in Precision Granite and Marble Private Limited, Surana Fabricators Private Limited, none of the other directors have condemned the act of J.B. Surana. Hence, the disqualification and termination of primary membership and life membership of the federation of all companies or firms wherein J.B. Surana is holding the post is warranted. That is the recommendation. Therefore, it should have been a notice even to other directors. At least the notice should have been in altogether a different format. Probably J.B. Surana would not have represented at all.
yes,
This background, the worship kindly take the improved order, the order under appeal.
yes,
The reasoning starts from para A, that is page 30.
yes,
Para 8 and 9. Again, what is sought is repeated. Then para F. According to the plaintiffs, though a notice stated so and so,
The plaintiffs have learned that as per the recommendation by the of the defendant number 4, by way of resolution passed in 292nd Executive Committee meeting of so and so, they were disqualified from the life membership of the First Defendant Federation. Plaintiffs were shocked to learn the said disqualification as they were not aware of any disqualification proceedings initiated against the plaintiff, that is the companies and the firm, and also to on what grounds plaintiffs have been disqualified. What are the deliberations with regard to the disqualification from the President, General Secretary, office bearers, and other members, whether requisite forum was met and procedure is laid down in the bylaw followed? Treating the said questions, the plaintiffs have made repeated requests for minutes of the meeting of executive committee meeting, but till now no reply is received. Thereby, the plaintiffs have been kept in dark about the said deliberations. With regard to the termination of membership and withdrawing the privileges, which is a serious action, there must have been an inquiry into the allegations leveled against any particular member to be established with certainty and beyond reasonable. Except issuing notice, no inquiry has been conducted. Articles of charges are not framed. List of imputation is not furnished. Documents relied thereon are not furnished. List of witnesses is not furnished. No inquiry officer is appointed. No opportunity is provided to the plaintiffs touching the allegation and imputations are concerned. Principles of natural justice have been violated, which are all serious consequences and repercussions. The bylaws of defendant number 1 do not provide a procedure following which plaintiff's hearing can seek immediate relief and an efficacious remedy, as there is no provision independent for independent right of appeal, nor there has been a detailed proper appeal procedure laid out for getting an equitable relief. None of the bylaw ousts the jurisdiction of the court with regard to adjudicating whether any requisite committee empowered by bylaw has followed the due procedure to conduct inquiry and impose punishment. Disqualification of the plaintiff is prima facie illegal, high-handed, and arbitrary. The claim of the plaintiff is resisted by the defendant on the ground. Sri so has filed the writ petition. Again, they have extracted their contention. 11 and 12.
Yes.
From page 36, para 13.
Yes.
Clause 7.8G of the bylaws of defendant number 1 federation requires a person who has any grievance with functioning of the federation should forward their grievance to the general secretary or to the president before taking any legal action against the federation or its office bearers. The plaintiffs have never availed the said remedy and have approached the courts of law seeking redressal of a fictitious grievance is the clear violation of 7.8G of the bylaws, which clearly goes to explain that any member who violates the above procedure stands disqualified. Along with this suit, plaintiffs have filed instant application praying this court to grant an order of temporary injunction to restrain the defendants from giving effect to or bringing into operation the resolution passed in so and so committee meeting held on 17/6/22. In so far as disqualification of the plaintiffs from the membership of First Defendant Federation, which is communicated to the plaintiffs by notices dated so and so, and consequently direct the defendants to extend all membership benefits to the plaintiffs by an order of temporary injunction against the defendants till disposal of the suit. Admittedly, Order 39.1 of CPC authorizes this court to exercise its discretionary power to grant an order of temporary injunction. The plaintiffs proved by affidavit that the defendants have illegally disqualified the plaintiffs and trying to give effect to the resolution passed in so and so. With regard to the disqualification of plaintiffs from the membership of the First Defendant Federation, which is communicated to the plaintiffs by the notice dated so and so, this court has got jurisdiction to exercise its jurisdiction by granting temporary injunction. restraining defendants from giving effect to the resolution till disposal of the suit. While exercising the discretionary power of this court has to apply 3 tests: whether the plaintiffs have prima facie case, whether balance of convenience lies in favor of the plaintiffs, whether the plaintiff could suffer irreparable injury if the prayer for temporary injunction is disallowed. Hence, it is for the plaintiffs to place the prima facie material before this court to prove the illegal termination. Whether the plaintiff's company has made out a prima facie case or not is to be discussed. It's an admitted fact that J.B. Surana, the director of plaintiff company, has been holding life membership of the first defendant federation. It should have been the other way around.
He is not personally, individually is not a member.
Further, it's an admitted fact that
No, this itself, this is the wrong this thing because
question itself wrong.
even that he has represented
Yes.
before this court as an individual, it is not on the company.
Further, it's an admitted fact that as per the proceedings of the executive committee, dated so membership of the plaintiff company was disqualified and the life membership was terminated. According to the plaintiffs, as per the show cause notice dated 26/11/21 and 20/12/21, an allegation was made against J.D. Surana stating that he had violated clauses 7.8 G and H of the bylaw. No allegations were made against the plaintiff's firms. The defendant, without conducting inquiry, terminated the membership and no inquiry was conducted. No opportunity is extended to the plaintiffs touching the allegation and imputations are concerned. Principles of natural justice have been violated. Bylaws of the first defendant not provided the procedure to be followed to seek immediate and efficacious remedy. Procedure for seek immediate efficacious remedy against the disqualification. There is no provision for independent right of appeal. The contention of defendants is that Surana, being the director, had filed a petition before the High Court of Karnataka for crashing the bylaw and also filed special petition before the Supreme Court and thereby violated SWIFT. With rival contentions urged by both sides, it just is necessary to go through the material available on record and carefully come to the copy of the proceedings of Executive Committee meeting dated so and so, produced by the plaintiffs, wherein it clearly discloses that first defendant federation has disqualified and terminated J.B. Surana from the life membership of the federation of all three companies. All three companies, firms, proprietary concerns held by J.B. Surana are being disqualified and the life membership is terminated. Whether the defendant federation has illegally terminated the membership of the plaintiff or not is to be discussed. As I have already stated above, defendant federation has specifically contended they have terminated the membership of plaintiff company for violating the bylaw. Hence, it is just improper to go through the bylaws of the Federation of Indian Granite and Stone Industry, which is produced on record by the plaintiff. For better appreciation, 7.8I, any member who violates the above clauses stands to be disqualified with following procedures. The action taken on the above clauses by a resolution of the Executive Committee passed at a meeting where subject is specifically listed in the agenda for consideration, provided always that in case of disqualification, termination of membership, the resolution be passed with 3/4 members present and members present in that particular meeting shall not be less than half the total strength of elected members of the Executive Committee for the committee. For the reasons stated above, the member so affected to be informed by the General Secretary, the member has the right to appeal to the general body if he or she so decides. Member so affected shall have been informed within 30 days his or her decision to appeal before general body through the General Secretary. The decision of the general body will be final and binding on the members. 78G and 78H were read earlier. Any member having grievance should go to General Secretary. Otherwise, under 78H.
No, only thing is that he has violated that bylaw class 7 and 8. By approaching this court, whether he has, one thing is that company has not approached this court. Even assuming that it is approached, it is only one company. That is, even though it is not by the company representing, even then if you are assuming that it is in one company which has been approached, other two company has not approached this court, then no notice has been given. That is what that you are concerned.
That's the next now. On careful reading of the above clauses of the bylaws, it is prima facie discloses that defendant federation has got every jurisdiction to disqualify any member who violates the clauses of bylaws. It shall be taken by the resolution of executive committee passed at a meeting.
Yes.
It is important to note that plaintiff's company have not disputed the fact of resolution passed by executive committee. It is not the case of the plaintiff that no notice was issued to their company. I don't know why the court below is observing this. Plaintiff's company have taken a specific contention. Company is not notified.
By individual notice has been given.
It's a specific contention. On the other hand, we have taken further contention that each company should have been heard. If it were to be any proceeding against the company, proceedings are conducted as if J.B. Surana is to be removed. His action. I point out that specifically in the claim we have taken that. In para 7 of the claim.
The company is the life member, not the surrogate.
Company is firm on the member. Two company, one firm.
He is not a managing director. He is one of the
Managing director. I understand. Even if notice were to be issued, it should have been issued to all the directors at least.
no illa managing director issue ಮಾಡ್ತಾರೆ. It's on behalf. No, it should be notice will be issued to that company.
But what should have been to the company.
Addressed to that company.
That company is removed. J.B. Surana will be disqualified is of no consequence. Company will be removed or terminated or such action will be taken. Then the court below,
Yes.
as I have already stated, the first defendant federation disqualified, terminated the membership of the plaintiff company held by J.B. Surana for alleged violation of rights. It is not the case of the plaintiff's company that they have not preferred a petition before the High Court of Karnataka in WP so. It is not the case of the plaintiffs that their company is not aware about the bylaws of the first defendant federation. The clauses referred in the bylaw produced by the plaintiff beneficiary discloses that first defendant has got a very jurisdiction to terminate the membership for violation of any of the clauses of the bylaw. Then it is pertinent to note that clause 7.8 provides that any member having grievance with the functioning of the federation should forward their grievances in writing to the President General Secretary to seek clarification before taking any legal action against the federation or its office bearers. As I have stated, Supra, J.B. Surana, being director of the plaintiff company, had preferred petition before the Honorable High Court of Karnataka challenging the amendment to the bylaw. Plaintiff has not produced material documents before this court to show that before approaching the Honorable High Court, J.B. Surana had forwarded his grievances in writing to the President General Secretary of the first defendant federation. The material available on record beneficiary is violation of clause 7.8G of the bylaws. By considering the violation on the part of the plaintiff company, defendant number 1 federation has rightly passed the resolution by terminating the membership. Apart from that, proceedings dated 17/6/22 passed in so meeting further discloses that an opportunity was also provided to the plaintiff company. Now the court below starts referring to plaintiff company.
Yes.
Plaintiff company to prefer appeal before the appellate authority annual general body meeting of the Federation of Indian Granite and Stone Industry against the decision of executive committee meeting in accordance with the bylaw, clause 7.8 I of Federation of Indian Granite and Stone Industry. The records show that plaintiff company, without availing the efficacious remedy of filing the appeal before the appellate authority, has directly approached the court. It is well established principle of law that when equally efficacious remedy is available, the court should not grant temporary intention as per section 41H of the specific relief act. Hence, I have no hurdles to hold that plaintiff company has not made out a prima facie case. Accordingly, point number 1 is answered in the negative. At this juncture itself,
We'll consider tomorrow.
One other aspect.
Tomorrow.
I'll just point out.
Yes. Then we'll have it tomorrow, Mr. Patel.
Next matter.
Huh? Yes, both. Yes, yes. Yes, Mr. Ashok, tomorrow or any tomorrow. This matter will have tomorrow. Yes. Yes, leave this matter tomorrow. Tuesday, 49 Tuesday. Huh? Tuesday ಬೇಕಾ Wednesday ಬೇಕಾ? Huh? ಬುಧವಾರ. Yes. 26. Yes. Tomorrow we have other matters also. Monday or Tuesday. Tuesday. Yes. 26 Tuesday. 25 also Tuesday. 40? Yeah, 49. Right. Ah, 49. Interim order granted earlier is extended till next date of hearing. ನಿಮ್ದೇನದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟದ?
Number 2, serial number 12.
Yes, leave this matter. You will take notice, ಅಲ್ಲ? Serial number ಎಷ್ಟು? Wait. Huh? 12 ಅಲ್ಲ? 12 ಅಲ್ಲಿ Sri Rajshekar S is directed to take notice. Office is directed to show his name. Then ಇದರಲ್ಲಿ 12.3 ಅಲ್ಲೂ ಕೂಡ Rajshekar is directed to take notice. Submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is overruled. Issue notice. Rajshekar is directed to take notice. Rajshekar, yes. Use this matter on Tuesday, Thursday and Friday, Wednesday. Yes. Wednesday andre date alla. Yes. Matter of vacation.
Serial number 12 ಇನ್ನೊಂದ್ಸಲ ನೋಡ್ತೀನಿ.
12.
ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ 15 ಅಲ್ಲ ಸಾರಿ 25 Tuesday, 26 Tuesday. 44 after vacation. 49 Wednesday interim order extended. 75, 76. 6 after. ನಾಳೆ ಇದೆ ಇರೋ.
ಆಗಿದೆ ಸರ್.
ಒಟ್ಟಿಗೆ ಆಯ್ತಲ್ಲ ಲಾಸ್ಟ್ ಒಟ್ಟಿಗೆ ಆಯ್ತಲ್ಲ ಲಾಸ್ಟ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಬಾಪ ಸೈನ್ ಹಾಕಿಸ್ಕೊಂಡು ಬೇರೆ ಇದೆರಡು ಸೈನ್ ಹಾಕಿಸ್ಬಿಟ್ಟು
ಇದು ಡೇಟಾ ಸರ್.
ಒಟ್ಟಿಗೆ ಸೈನ್ ಹೋಗ್ತೀಯಲ್ಲ
ಓಕೆ. ಇಲ್ಲೊಂದು
ಬಿಚ್ಚಿದೀನಿ ಅದಕ್ಕೆ ಹಾಕೋ. ಇದೊಂದು ನನ್ನ ಹತ್ರನೇ ಇರ್ಲಿ. ಅದು ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಮೇಡಮ್ ಕೊಟ್ಟಿರೋ ಚೇಂಬರ್ ಇಂದ ಸೋಮವಾರಕ್ಕೆ ನಾವೇ ಕೊಡ್ತೀವಿ. ಇಲ್ಲ ಮೇಡಮ್ 2 ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತಾರೆ. ಇಲ್ಲಿ ಕಥೆಗಳು ಕೇಳಿದ್ರೆ ನೀವು ಏನೋ ಬರ್ಕೊಂಡಿದ್ದೆ.
ನೀವು ಬರ್ಕೊಂಡಿದ್ದೀರಾ? ಹೌದಾ? ಏನಾಗ್ತದೆ ಬೆಳಿಗ್ಗೆ ಇರೋದು ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ಅದೇ ಬೆಳಿಗ್ಗೆ ನಾನ್ ಬರ್ಕೊಂಡಿರೋದು ಅದಕ್ಕೆ
ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಮಧ್ಯಾಹ್ನ ಯಾವ್ದೋ ಒಂದ್ ಬಿಟ್ಟಿದ್ದೀನಿ. ಹೌದಾ?
ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಬಟ್ ಯಾರ ಗಮನಕ್ಕಿಲ್ಲ ಬೆಳಿಗ್ಗೆ ಇರೋದು ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಲ್ಲ ಅಂತ ಅವರು.
ಯಾವ್ದೋ ನೋಟ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ನಾಳೆ
ಬಾಯ್ ನಾಳೆದ ಮೇಡಮ್ ನಮ್ದು ಟೀಮ್ಗಿಂತ ಸುಲ್ತಾನ್ ಹೋಗಿದ್ದೀವಿ.
ಕೊಡಿ ಸರ್, ಡೇಟ್ ಮಾಡಿ ಕೊಡಿ ಸರ್.
ತಗೊಂಬಲ್ಲಿ ಆಟೋ ಶೀಟ್ ಅಷ್ಟೊತ್ತು ರೆಡಿ ಮಾಡುತ್ತೆ. ಇನ್ನೊಂದು ಕೊಟ್ರ ಮೇಡಮ್? ಇನ್ನೊಂದು ಕೊಡಮ್ಮ. 2 ಆಟೋ ಶೀಟ್ 2 ಕೊಟ್ಟಾರ ನೋಡಮ್. ಮತ್ತೆ ಆರ್ಟ್ ಶೀಟ್ ಎಲ್ಲ ಚಿಕ್ಕ ಮಾಡಿದ್ದೀನಪ್ಪ. ಅದಷ್ಟು ಬೇಗ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡು ಹೋಗ್ಬೋದು. ಆಮೇಲೆ ನಾನು ನಿಮ್ಗೆ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿಲ್ಲ. ತುಂಬಾ ಅಂತ ಏನ್ ತಲೆ ತಿನ್ಸಾಯ್ತಾ ಇದೆ. ಇದು ಹೋಗಿದ್ದೆ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು. ಹಿಂದೆ ಬರ್ದು ಬಿಟ್ಟಿದ್ರೆ ಸರಿ ಹೋಗಿ ಪ್ರಾಬ್ಲಮ್ ಸುಮ್ಮನೆ ತಲೆ ತಿನ್ನಾಕ್ಬಿಟ್ಟು ಫೋನ್ ಮಾಡಿದ್ರು. ಅದ್ರ ಮತ್ತೆ ಈ ಮೇಡಮ್ ಇಲ್ಲ ನಾನು ಕರೆಕ್ಟ್
ಅಲ್ಲಿ ಚೇಂಬರ್ಗೆ ಬಂದ್ಬಿಟ್ಟು ಅವರಲ್ಲಿ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು